Tomorrow day to tomorrow they'll arrange the work. They are ನೋಡ್ಕೊಳ್ತಾರೆ ಎಷ್ಟು ಬ್ಯಾಕ್ಲಾಗ್ ಇದೆ ನೋಡ್ಕೊಂಡು ಮಾಡ್ತಾರೆ. ನಾಳೆನೆ ಬರುತ್ತೆ ಬಟ್ ಜಾಸ್ತಿ ಇದ್ರೆ ನಾಳೆದಕ್ಕೆ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ. ಕೊಡಿ ಕೊಡಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದು ಕೊಡಿ ಕೊಡಿ. Correction regarding what? You did not argue that. You did not argue like that. Give me the memo. I'll look at the file. If I feel there's something, I'll post it for the expert. Number one, for order. Number one. Next witness. Number two, memo file stating that the first petition is dead and our LR is already on record as a second petitioner. The memo is accepted and a note be made in this regard in the cost state. Since the right to sue survives on the applicants IA 1/2020, they are permitted to come on record as the LRs of the deceased for the respondent. Who is R3? Or you know Vakilva? Correct, but Tamaya is there. I appear. You appear for? LRs of R3. They're already on record, alva? The LRs of R3A. Yes. Since the LRs of R3A are already on record as R3B to D, no steps need be taken in respect of deceased R3A. Then what is this non-maintenance of IA 1 to 4? R3. Learned Council seeks permission to withdraw IA1/21 to IA4/21. So permission is granted. IA1/21 to IA4/21 are dismissed as not pressed. Then what is memo for withdrawal? Does the memo survive? Does the memo survive? I simply say memo for withdrawal does not survive in view of the application is allowed. Memo for withdrawal. The details of LRs of deceased R4 does not survive since IA1/2020 is allowed. First state amendment. First state will be amended. Annexure H. Annexure H. Page number 23 and 20. Like computer how can it go? Where is the Senate Council submits? Yeah, memo area. Council submits that an endorsement has been issued by the authorities stating that page number 23 and 24 are not available even in the original, and hence you cannot produce the certified copies containing page 23 and 24. So the submission is accepted. Then the AGA is directed to secure the records of the Assistant Commissioner. As against yes, you can go to the DC. It is not in dispute. Final order. The order sheet it is not in dispute that the impugned order is passed with the Assistant Commissioner, and as against the order of the Assistant Commissioner, an appeal is maintainable to the Deputy Commissioner under Section 14 of the Land Revenue Act. In view of the above, the petition is dismissed, reserving liberty to the petitioner to prefer an appeal to the Deputy Commissioner within a period of 4 weeks from today. And I have granted you 4 weeks. 2 weeks. 2 weeks. Who's for the petitioner? Whom do you want to implead? Accurate. What is the subject matter of this petition? Impleading application allow the application, the office objections, are overruled. Since the proposed respondent claims to be a purchaser of a portion of the property in respect of which mutation is being sought, in my view, it would be a necessary and proper part. Hence, IA 1/2022 is allowed. Cost title be amended immediately. Cost title made. I allowed me lage. Office is also directed to show the name of the counsel who has filed the application for impleading as appearing for external respondent. You want conversion? I oversight. The office has registered an application for recalling as a writ petition itself. That view of the matter, the writ petition is disposed of, and the application which has been numbered as a writ petition shall be treated as an application for recalling. Recalling the application filed for recalling the order passed in WP number 23208/2012 and 23209/2012. 23209/10. February 8 and 2008 and 2009 and 10. 23208-2320-210. One week. Second time, 1 week. ಮಾಡಿದರೆ ದುರಸ್ತಿ ಮಾಡಿದರೆ ಅದರಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ ನಿಮಗೆ. An application is filed seeking for extension of time for consideration of the representation of the petitioners. As requested, time to consider the representations is extended by a period of 6 months from today. Which are 15 in the model. Chikvenkataya.
Shri Krishnamurti.
Since the right to sue survives on the LRs of the deceased third petitioner, the applications filed to bring the applicants on record is allowed. So the delay in filing the application and the abatement is also set aside. Accordingly, IA 1/18 and 1/19 is allowed. IA 1 and IA 2/19 is allowed. Similarly, since right to sue survives on the applicants in IA 3/19, the application is allowed and they are permitted to come on records as the LRs of the deceased first petition. Cost rate will be amended issue notice on IA 1/17, 2/17 and 3/17. Post in the month of July. Date but July 1st week. In direction. Who's for the respondent? IA 1/21 ಅಂತ ಹೇಳುತ್ತೆ. IA 1/22 is for amendment. Now, what is IA 1/21? Then bedwega. Who's for the respondent? Where amendment ಕೇಳ್ತಿದ್ದೀರಾ? ಯಾವ ವರ್ಷ? ಅದು ಮೊನ್ನೆ ಇತ್ತಲ್ಲ ಅದ? Since the application for amendment is not opposed, the same is allowed. The petition be accordingly amended. Next bit. ಅದನ್ನ ಕವರ್ಡ್ ಅಂತ ನೋಡಿದ್ರೆ ನೋಡಿದ್ದೀರಾ? Next witness. Next witness. A1 for dispensation is allowed. The 136(3) second time. Where? Page number is what? Page number? Internal page? How was he considered this? I'll send it back. No, but he has not applied his mind to this aspect of the matter. No, but I understand. But without there being a finding from him, I'll be sitting in judgment over that and passing an order. He cannot keep doing this proceedings again and again. He has done it at the earlier instance. 136 he himself responds the earlier instance. Challenge and no, but How can he pass an order in the light of his own earlier order? That is the argument, isn't it? This division bench did not say ignore the earlier order and pass. Then how can he do this? So he can theoretically ignore his earlier order and pass a completely contradictory order. Then the iವ್ರ ಮೇಲೆ ಏನು action ಬೇಡವಾ ಸುಮ್ಮನೆ ಅಷ್ಟೇ. No, but he could have passed an order once having noticed it. Should he not say something about it? That deputy commissioner. ಏನ್ ಮಾಡ್ಲಿ? No, but if he's done it deliberately, then where is the earlier order? And this was challenged. Wait, annexure. Filed by the state. A claim was made to enter the name of M. Kempanna and Krishnamma in respect of cell number 115 of Chansandra village, Vidroli Hobli, Bangalore East Taluk, in column number 9 and 12(2) of the RTCs. The Special Deputy Commissioner, by an order dated 18th of November 2010, in RRT bracket 2 bracket E CR 6/2010-2011, passed the following order, page 82. This direction to restore the names of the aforementioned Kempamma, person, Kempanna and Krishnamma was challenged by the state in WP number 28765/2011. This writ petition was heard along with a batch of other writ petitions, and this court, by an order dated 4th of November 2011, upheld the order of the Deputy Commissioner and dismissed the writ petition filed by the state. Next, the state being aggrieved by the dismissal of the writ petition, preferred writ appeal in writ appeal number 2206/2013. The division bench of this court, by an order dated 9th of October 2013, dismissed the appeal and affirmed the order of the learned single judge. Thus, the direction to enter the names of Kempamma and Krishnamma on the basis that there was a valid grant was confirmed with the division bench of this court and has attained finality. However, thereafter, The national respondent. Over there are respondents 3 and 6, 3 to 6, 4 to 6 lodged a complaint alleging that the entries in favor of the aforementioned were illegal. Annexure. Where is your petition? The respondents 4 to 6 preferred WP 1549/2021 in the form of a public interest writ petition. In that writ petition, the prayer was sought to direct the second respondent here. Who is second respondent? The page is missing. Correct, huh? Because of that page is missing in my file. Deputy Commissioner Tahsildar. Because that page is missing. Where is the order? Cost rate ಗೊತ್ತಾಗುತ್ತೆ. Cost rate ನಲ್ಲಿ ಆ page missing ಇದೆ. Directing the second respondent there to hold an inquiry in respect of the alleged grant dated 16/1/1965 made in favor of the division bench of this court passed an interim order on 24/8/2021, which reads as follows, page 282. Pursuant to the said order, the Deputy Commissioner has held an inquiry and has passed the impugned order holding that the grant certificate and the Sagoli check, the grant certificate dated 16/1/65 was not genuine, and the official memorandum dated 10/7/1964 issued by the Deputy Commissioner, Bangalore Rural District, granting the land was inoperative. It may be pertinent to state here that before the Deputy Commissioner, the contention was raised that the validity of the grant had been gone into on an earlier occasion, and it had been held that the grant was valid, and that order of the Special Deputy Commissioner was also affirmed by in a writ petition and a writ appeal. This contention has in fact been noticed by the Deputy Commissioner at para 9 of his order, which reads as follows. Though the Deputy Commissioner has noticed that in an earlier proceeding, the grant in favor of the petitioners was held to be valid, and the order directing restoration of the revenue entries was also upheld by this court. He has nevertheless proceeded to hold that the grant dated 16/1/65 was not genuine. In my view, the Deputy Commissioner had absolutely no jurisdiction to ignore the earlier proceedings, which culminated by an order of the division bench upholding the grant in favor of the petitioners. The order passed by the Deputy Commissioner in total ignorance of the earlier proceedings cannot be sustained. The order of the Deputy Commissioner is accordingly quashed. The revenue entries as it stood prior to the order of the Deputy Commissioner shall stand restored. WP is accordingly allowed. One cycle. You want me to? I'll I can fill up the pages, but I thought division bench was enough. All the others are basically orders of the administrative authorities. Sorry, but I think we stand on a better footing once we have confirmed it. What? They are vacating after that. ಕೇಳನೇ ಅವ್ರು ನೀನು ಅರ್ಜೆನ್ಸಿನ ಪರವಾಗಿಲ್ವಾ ಟೈಮ್ ಕೊಡ್ಲಾ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಂದ್ರೆ ರೀಚ್ ಆಗಲ್ಲ 2019 ಮ್ಯಾಟರ್ ನನಗೇನಿಲ್ಲ ಮಾಡ್ತೀನಿ 2 weeks ಆದ್ಮೇಲೆ ಕೇಳ್ತೀವಿ Why did you not make an application here? Why did you have to go to the Chief Justice of India? ಅಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ಕಾಗ್ತಿರ್ಲಿಲ್ಲ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ರೆಡಿ ಇದ್ದಾರೆ ಇವತ್ತು ಅಲ್ಲ ಯು ಗೋ ಟು ದ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ಇಂಡಿಯಾ ಅಂಡ್ ಸೇ ದಟ್ ದಿ ಮ್ಯಾಟರ್ ಇಸ್ ಟು ಬಿ ಸರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಹಂಗಾರೆ ಇವಾಗ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಅವರು ಸಿಜೆ ಹೋಗಿದ್ದಾರೆ ನೀವೇನು ಇಂಥ ಕೇಸಲ್ಲೂ ನೀವು ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ರೆಡಿ ಆಗಿ ಫಾರ್ ವಾಟ್ ಬೇಡ ನನ್ನ ಹತ್ರ ಬೈಸ್ಕೊಳ್ತೀರ ಸುಮ್ಮನೆ ನೀವು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ರೆಡಿಯಾಗಿ ಬನ್ನಿ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ they have approached the Chief Justice of India, at least have some registered partition. What is the reason given by the?
There are several, including RSA is pending for the fund. There is a fund for more than 1 acre.
RSA ಜೊತೆ post ಮಾಡಕ್ಕೆ ಹೇಳ್ಬಿಡ್ಲಾ? Post this petition along with RSA. ಅಲ್ಲೇ ಕೇಳಲ್ಲ ಅಲ್ಲಿ RSA ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋಕೆ ಕೊಟ್ಟಿದ್ರೆ ಗೊತ್ತಿಲ್ಲ ನನಗೆ. ನಾನು ಒಂದು ಆರ್ಡರ್ ಕೊಟ್ರೆ ಅಲ್ಲೊಂದು ತೊಂದರೆ ಆಗುತ್ತೆ. ಕಾಂಟ್ರಡಿಕ್ಷನ್ ಬೇಡ ನೀವು ಅಲ್ಲೇ ಹೋಗಿ ಕೇಳಿ. Post along with RSA number. Next sir.
Next page number 30. 79.
Notice ilva?
Notice ಇಲ್ಲ. Number 3. ಅರ್ಜಿದಾರರಿಗೆ ಕಳಿಸಿದ ನೋಟಿಸ್ ಜಾರಿಯಾಗದೆ ವಾಪಸ್ ಬಂದ ಪ್ರಯುಕ್ತ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳ ಆಧಾರದಿಂದ
this writ petition is filed challenging an order as by the Assistant Commissioner ordering forfeiture of the lands purchased by the petitioner on the ground that they were in contravention of Section 79 capital A and Section 79 capital B of the Land Reforms Act. The impugned order itself indicates that the notice sent to the petitioners had not been served, and despite that fact being recorded, the Assistant Commissioner has proceeded to pass the impugned order on the basis of the records available with him. In my view, this order is in gross violation of the principles of natural justice and therefore cannot be sustained. It is accordingly quashed. The Assistant Commissioner shall afford an opportunity of hearing to the petitioners and thereafter pass an order in accordance with law. So the petitioner to appear before the Assistant Commissioner on 30th of June. 2 weeks. You know?
2 weeks time.
2 weeks. Or allow ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಟೈಮ್ ಕೇಳ್ತೀವಿ. ಬರ್ಲಿ ಬಿಡಿ, after 2 weeks ಬರ್ಲಿ ಬಿಡಿ. ಎನ್ನೇ ಯಾವ್ದು ಮ್ಯಾಟ್ರ್? ಎನ್ನೇ ಮ್ಯಾಟ್ರ್ ಅಂತ ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್, ಸೇಮ್ ಆರ್ಡರ್, ಅದೇ ಟರ್ಮ್ಸ್. This invitation is quite challenging. In order of forfeiture made by the Assistant Commissioner on the ground that the lands purchased by the petitioners were in contravention of section 79 capital and section 7 capital of the United Council. In the impugned order itself, the Assistant Commissioner has recorded that the notices sent by RPAD and through the Tahsildar were not served on the petitioner. But nevertheless, the Assistant Commissioner has proceeded to pass the impugned order directing forfeiture of the lands. I view this order is in gross violation of principles of natural justice and cannot be sustained. It is accordingly quashed. The Assistant Commissioner shall, the matter shall stand remitted to the Assistant Commissioner, who is directed to afford an opportunity of hearing to the petitioner and thereafter ask a fresh order in accordance with law. The petitioner to appear before the concerned Assistant Commissioner on 30th of June.
Lords, I appear for the petition of Lords.
Yes.
Lords, I am seeking for the writ of mandamus, Lords. Directly responded to mutate the revenue entries, Lords, in favor of the petition of Lords.
DC again revision hakilwa?
Lords?
Has any revision been filed with the Deputy Commissioner?
No, my Lords.
Are you sure?
Yes, my Lord. 100%. I'm sure, my Lords.
The prayer in the petition is for a direction to the respondents to mutate the revenue entries in favor of the petitioner as directed to the Assistant Commissioner in RA number (S) 244 of 2016-17. It is stated that though the order of the Assistant Commissioner has become final, as much as no revision is preferred, there is complete inaction on the part of the respondents in complying with the direction of the Assistant Commissioner. In the light of the fact that there is an order of the Assistant Commissioner directing mutation of revenue entries in favor of the petitioner, it will be necessary to direct the Tahsildar to consider the claim of the petitioner and act in accordance with the order of the Assistant Commissioner and pass appropriate orders. Such an exercise should be undertaken and completed within a period of 3 months in the rate of result of this order.
But the case number is RRT numbers different out of the semester.
Yes, the Tahsildar.
That is also that is by the special DC.
Commission for the special DC.
Special DC RRT number bucket
2S. This year by DC model, special DC model, RRT 2S CR 2/21/22.
Oblate notes.
Next one.
24,
I am for the petitioner.
ಕೃಷ್ಣಮೂರ್ತಿ
Yes, madam. I am for the petitioner.
ಮಾತಾಡ್ಲಿಲ್ಲ ನೀವು, ನಾನು ಅಡ್ಜರ್ ಮಾಡ್ಬಿಟ್ಟು ಆಗ್ಲೇ.
May I request the Lordship to kindly take up the
Yes.
serial number 23, madam.
What is annexure G?
Annexure G is the order passed by the Assistant Commissioner under section 79A and B. In the order, it is noted that I have served with the notice. In fact, I was not served with the notice, both in this proceedings, and subsequently the name of the government is shown in the RTC entries. Then also I have not received any notice.
ನೋಟಿಸ್ ಜಾರಿ ಆಗಿಲ್ಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಾರ?
ನನ್ನ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿದೆ.
ಎಲ್ಲಿ ಹೇಳಿದಾರ?
At page 5. In the course of the order, the second respondent has observed that the notice of the proceeding was sent to the petitioner through registered post. It is submitted that the petitioner has not received any such notice. Subsequently, at ink page 5, para 4.
ಬಿಡಿ, ಅಮೆಂಡ್ ಆಗಿದೆಯಲ್ಲ, ವಾಪಸ್ ಹೋಗಿ. The impugned order, by the impugned order, the Assistant Commissioner has ordered forfeiture of the lands purchased by the petitioner on the ground that it violated section 79 capital A and section 79 capital B of the Act. In the impugned order, it is stated that the copies of the notices sent to the petitioners were served, and yet the petitioner did not appear before the Assistant Commissioner. And consider the petitioner over contents that notices were not served on the petitioner, and a specific government in that regard is made in the petition. In my view, having regard to the fact that the proceedings under section 83 for forfeiture have drastic consequences on the holding of a person who has purchased agricultural land, it would be necessary to afford a reasonable opportunity of hearing to the respondent, to the petitioner, to the purchaser before passing any order. Since the impugned order is admittedly passed without hearing the petitioner, the same would have to be set aside, and the matter is required to be remitted to the Assistant Commissioner. So direction to the Assistant Commissioner to hear the parties, to hear the petitioner, and thereafter pass a fresh order. Accordingly, annexure G is quashed. The matter shall stand committed to the Assistant Commissioner. The petitioner shall appear to the Assistant Commissioner on 30th of June and take further instructions on the matter. 30th June.
Yes, my lord, I got.
Yeah, outclass ಮಾಡ್ಬೇಕಲ್ಲ.
ನೀವು ನೋಡಿದ್ದೀರಾ? ಈ ತರ ಮಾಡ್ಬೋದಾ? ಅನಧಿಕೃತ ಬಡಾವಣೆ ಆಗಿದ್ದು ಕ್ರಯದ ವಹಿವಾಟನ್ನು ನಿರ್ಬಂಧಿಸಿ. ಅಲ್ಲ, ಅದ್ರಲ್ಲ ಕಾಲಮ್ ನಂಬರ್ 11 ಅಲ್ಲಿ ಏನ್ ಹಾಕ್ಬೇಕು ನೀವು? ಅಲ್ಲ, what is column number 11 meant for? About any encumbrance, isn't it? ಈ ತರ ಹಾಕೋದು. ಅದ್ರಲ್ಲಿ ನೀವು ಅನಧಿಕೃತ, you declare that it is unauthorized. Did you hear him before you pass this order? ಅಲ್ಲ, ಸರಿ, ಅದಕ್ಕೆ ಫೈನ್ ಮಾಡ್ಬೋದಲ್ಲ ನೀವು? ಅದಕ್ಕೆ ನೀವು ನೆಟ್ಟಿಗೆ ನೀವೇ, if a person uses agriculture and unauthorizedly, you can collect a fine. That is all the act provides. If he has formed an illegal layout, then there is other authorities to take action. Can you make an entry like this? You must give a self-declaration, ಸರಿಲ್ಲ ಇವನು ಅಲ್ಲ ಕರೆಕ್ಟ್, ಬಟ್ ಪ್ರೊಸೀಜರ್ ಅವ್ರು ಫಾಲೋ ಮಾಡ್ಬೇಕು ತಾನೆ. ಅವ್ರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರಾ? Issue notice. When a AG accepts notice, correspondence. So the next date of hearing, there shall be an interim order of stay of annexure. J and K, na? J and K. The petitioner shall also maintain status quo as it exists today.
Landlord sons.
81 order.
His father was attending to the tenant. And there was no communication.
You are the landlord or the tenant?
We are the landlords.
Ramaya is your father.
Ramaya, actually Ramaraju is the uncle. Ramaraju purchased the property. Yes,
ಅಲ್ಲ ಇವಾಗ ಇಲ್ಲಿ ರಾಮಯ್ಯ ತೋರಿಸಿರೋರು ನಿಮ್ಮ ಅಂಕಲ್.
ಹೌದು, ರಾಮರಾಜು ರಾಮಯ್ಯ ಇದ್ದಿದ್ದಾರೆ. ರಾಮರಾಜು ಇದ್ದಿಲ್ಲ by that time. It was not the
What is your father's name?
father's name, Musamiraj. Musamiraj, third son of Punraj. Fourth son is Ramaraj. Thereabouts not more than 45 years ago.
First paragraph of the annexure here, page 35.
The land paper went to South Park of the application. The application for an order confirming the occupancy right of place of 14.7% of superintendent on the admission of one Musami Raju. Musami Raju was attending the case.
Mutsami Raju is your father. If he admits,
No, there is one sufficient. There is no records to show that Vara is given to the landlord.
correct, but ನಿಮ್ ತಂದೆ ರೈಟ್ ಅವ್ರ ಹಂಗ ಒಪ್ಕೊಂಡ್ಬಿಟ್ರು ಅವ್ನು ಟೆನೆಂಟ್ ಅಂತ.
He has filed a written statement stating that was not cultivated, none of the person cultivated the area.
This statement was recorded of your father. Your father did not challenge it. Thereafter,
Father was not informed everyone. And there are so many errors are there.
ನಿಮ್ ತಂದೆ ಬದುಕಿದ್ರೆ ತಾನೆ ನಿಮ್ ತಂದೆ ಆಗ್ತಿರೋದ್ರು.
And one thing, the tenants were not cultivated.
That is on the merits.
Without discussion, all the errors were not brought in record.
ನಿಮ್ ತಂದೆ ಬದುಕಿದ್ರಲ್ಲ, how can they bring the errors on record?
Only Ramaya was, Musamiraj was attending the case.
ಕರೆಕ್ಟ್, ಅವ್ರು ಬದುಕಿದ್ರು ಅವ್ರು ಬಂದು ಒಪ್ಕೊಂಡ್ರು. ಬನ್ನಿ ಮೇಡಮ್, ಬನ್ನಿ ಮೇಡಮ್.
Recently, he came to know in 2020.
In this writ petition,
Is not reflected in as an monthly register for our reference in RTC.
in this writ petition,
I produced the RTC on the RTC.
that is on the merits. I am not convinced about the delay. It may be a wrong order. I will consider. I will consider. In this writ petition, the order of the land tribunal dated 29/10/1981 is challenged. The petition is presented on 12th of April 2022. In other words, this writ petition is filed after a period of nearly 19 plus 24, 41 years. In paragraph 1, in the first paragraph of the implement order itself, it is stated that one Muniswami Raju was one of the co-owners of the land, had admitted or had conceded for confirmation of occupancy rights in respect of 3 acres 14 guntas in survey number 72/2 of Tubradi village. He said Muniswami Raju is none other than the father of the petitioner. In my view, since the father of the petitioner appeared and conceded for confirmation of occupancy rates, and an order was also passed in that regard on 17/4/76. The petitioner cannot be permitted to challenge the subsequent order passed by the land tribunal, in which one Ramaya, who is stated to be the uncle of the petitioner, had appeared as a respondent. In my view, since the father of the petitioner had appeared before the land tribunal way back in the year 76 and had conceded for conferment of occupancy rates, the petitioner would have absolutely no right to challenge the said order. So it is also admitted by the counsel for the petitioner that his father passed away in 82-83, and though nearly 40 years have elapsed since then, the petitioner, for reasons best known to him, did not challenge the order passed on the basis of his father's admission. The counsel contends that the petitioner was a minor and was therefore unable to take any action. In my view, since the father of the petitioner appeared and conceded for conferment of occupancy rights, the petitioner will have no locus standi to question the said order. The petition fails and is therefore dismissed. AB. But aguತ್ತಲ್ವಾ? Dismissed as time barred. The appeal of the year 2017. Petition ಇದೆಯಲ್ಲ, ಯಾವತ್ತು ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ ಅದು? 13 ಜುಲೈ. ಏನ್ ಮಾಡಿ? 18 March 2020, 2022. 2022 ತಾನೆ? ಇಲ್ಲ 2020 ಅಂತ ಇದೆ. Then how can it be numbered as 2022? 2 ವರ್ಷ. ಅಬೇಟ್ ಆಗುತ್ತೆ. This petition is filed challenging an order of forfeiture passed by the Assistant Commissioner for alleged contravention of Section 79 A and Section 79 B of the Land Reforms Act, and also the order of the Karnataka Appellate Tribunal, which confirmed the said order by an order dated 20th of December 2019. This writ petition has been preferred on 18th of March 2020. It is not in dispute that Section 79 A and Section 79 B of the Land Reforms Act were omitted by Act number by ordinance number 13/2020, which was later replaced by Act number 56/2020. So, Section 13 of the ordinance and Act Section 12 of the Act states that all cases pending before any court as on the date of promulgation of the ordinance would stand abated. Since the petition was pending on 18th of March 2020, that is before the ordinance was promulgated on 13th of June 2020, the proceedings under section 79A and section 79B statutorily stand abated. Consequently, writ petitions allowed annexure A and B are quashed on the ground that the proceedings are abated by virtue of section 12 of Act number 56 of 2020. 13 July nadu. 13 July nadu. 13 July nadu. July nadu. 13 July. ಯಾರಿಗೆ ಬೇಡ ಇವತ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನಂತ This writ petition is filed challenging the rejection of the petitioner's application for permission to use this agriculture land for residential purpose. The reason for rejection is that, as per Malu town plan, the reason for rejection stated in the order is that the town planning authority objected to the conversion on the ground that the master plan was yet to be finalized. It is not in dispute that this court in WP 20606/2021 decided on 19th of November 2021 has held that the Deputy Commissioner is required to consider the case of the applicants without awaiting the approval of the final master plan. In that view of the matter, the impugned order cannot be sustained and it is accordingly quashed. The Deputy Commissioner shall consider the application of the petitioner without reference to the master plan said to be awaiting approval and pass appropriate orders in accordance with law within a period of 3 months from date of receipt of a copy of this order. After 4 months ಕೊಡ್ಬೇಕು ನಾನು ಅಲ್ಲ ರಿಜೆಕ್ಟ್ ಆಗೋಗಿದೆಯಲ್ಲ ಅಲ್ಲ ಆಕ್ಚುಲಿ ಡೀಮ್ ಕನ್ವರ್ಷನ್ ರಿಮೈಂಡ್ ಬರಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ ಬರುತ್ತೆ ವಾಟರ್ ಸೆಟೇಷನ್ ಮಾಡಿ ರೀಕನ್ಸಿಡರ್ ಮಾಡಿದಾಗ ಆತರ 4 months ಕೊಡಕ್ ಬರಲ್ಲ ಸುಮ್ಮನೆ 3 months ಅಂತ ಹೇಳ್ಬಿಡ್ತೀನಿ if you want to disagree with it, I'll disagree with it. 3 months.
Position has not been delivered. But when it was required before the Deputy Commissioner as well as Tashikar Martin, it was not to understand that there is some dispute with respect to lands. But there is no infrastructure at all with respect to approach these lands. Therefore, what representation has been made to the Deputy Commissioner either to provide infrastructure and put the petitioners in possession as per their grant, or allot alternative land, which has not been considered.
So the DG accepts notice for respondents and seeks time to secure instructions. Released on 30th.
next time also writing.
Same 29-30.
You know, 31, official trial.
Next sheriff. What is the next sheriff? Page number ಯಾವುದು? Next sheriff. DC ಗೆ ಹೋಗಕ್ಕಾಗಲ್ವಾ? ನಿಮ್ಮ ಹೆಸರೇನು? Confirm. Your appeal was against which order? Your suit was dismissed. Appeal? So no, therefore there is no declaration in your favor.
Therefore, I filed appeal before this court. The appeal, when the appeal is pending, the appeal can be dismissed. The sole respondent came. The inquiry number 62.
So even if the second appeal is dismissed, there is no declaratory decree in your favor.
Pending abate.
So abate ಆದರೆ but ನೀವು ಓನರ್ ಅಂತ ಅನ್ನೋದಕ್ಕೆ ಏನಿದೆ? You filed a suit for declaration. Which appeal? Dismiss ಆಯ್ತು ಅಂದ್ರೆ? ಅಲ್ಲ ಸೋಮಶೇಖರ್, but so long as the second appeal is dismissed, how can there be an entry in your favor? ನಿಮ್ದು ಆರ್ಯ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. Question of right. ಸರಿ, therefore you do not have a declaratory decree in your favor. ನೀವು ಓನರ್ ಅಂತ ಅನ್ನೋದಕ್ಕೆ ಕೋರ್ಟ್ಗೆ ಹೋದ್ರೆ ನಿಮ್ಗೆ ಕೊಡ್ಲಿಲ್ಲ ಆರ್ಡರ್ನ. That is also dismissed as well. What is your right to challenge it once your claim for declaration that you're the one that has been dismissed? What is your right to question it? ಅವ್ರ ಕೋರ್ಟ್ ಹೋಗಿಲ್ಲ ಸೋಮಶೇಖರ್, ಹೋಗಿರೋದು ನೀವು. ಮತ್ತೆ your suit is dismissed, confirmed in appeal and in second appeal. ಆದ್ರೂ ನಿಮ್ಮ ಹೆಸರು ಬರ್ಬೇಕು. ಅದ್ರ ನೀವು ಕ್ವಶನ್ ಮಾಡಕ್ ಆಗತ್ತಾ ಅಂತ ನಾನು ಕೇಳ್ತಿರೋದು. ಅವ್ರ ಟೈಟ್ಲ್ ಇಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳೋಣ, ನಿಮ್ ಕ್ಲೇಮ್ ಅಂತ ವಜಾ ಆಯ್ತಾನೆ. What can we do? You may have to file a separate suit, but how can you ask for? If there are no LRs, you can make an application asking for some other person to be appointed to continue the second appeal, because your rights are involved. If you accept the dismissal, then the matter comes to an end. Okay, so what do you want us to do? You want us to find out who the LRs are? Then whether they can take steps or not, it is not for you to question. You have lost. Court ಅಲ್ಲಿ ಸೋತಿದ್ರ ನೀವು. ಮತ್ತೆ ಸುಮ್ಮನೆ ಯಾಕೆ you are forcing me to say that since the dismissal of your suit precludes you from challenging the entry in favor of a dead person. ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿದ್ರಿ ನೀವು. Question of right is kept open. ಏನಿಲ್ಲ. My suggestion is do something in the second appeal. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗ್ತೀನಿ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಇನ್ನೊಂದ್ಸಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗ್ತೀನಿ ಇನ್ನೊಂದ್ಸಲ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಏನಾಗಿದೆ ಎಫೆಕ್ಟ್ ನೋಡಿ. ನಿಮ್ದು ಅಪೀಲ್ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ವಜಾ ಆಗಿರೋದು ಏನು ಅಂತ ನೋಡಿ. ಎಫೆಕ್ಟ್ ವಾಟ್ ಇಸ್ ದಿ ಎಫೆಕ್ಟ್ ಆಫ್ ದಟ್? It will tie my hands. I cannot do anything here until you make an application there. And 2 weeks.
My lord, I am appearing for the petitioners in this case, my lord. The order under challenge is at annexure A and B passed by the assistant commissioner and the deputy commissioner respectively, wherein, my lord, the respondent number 1 and 2 made an application for change of khata in their name in respect of survey number 22/1P1 and 22/1P2, for which, my lord, my father was the owner, and there was a tenancy claim in respect of the said land, and we fought the litigation for 30 years, my lord. Matter went up to Supreme Court and we have succeeded. Thereafter, my lord, on the basis of 1965 decree, now they want to get their name entered on the basis of the will executed by their father. Now, my lord, will has not been probated.
What was your status with the land terminal, landlord or tenant?
Landlord, my lord. Landlord. Tenancy claim was rejected.
The form number 7 filed by this Coelho and
no, not Coelho. Third parties. I have produced the copy of the order.
How does it bind them? How does it bind them then?
No, it is not binding them. What I am submitting, my lord, we are the owners of the property in question. The respondent's number 4 has no right over the property at all. On the basis of the alleged will, my lord, without any notice to us, now the order has been passed. There is no notice at all. We have not been represented. No opportunity was given for us. And it is only...
How does the deputy commissioner deal with this?
Now, deputy commissioner says, my lord, insofar as the notice is concerned, my lord, he doesn't say anything. Now, your lordship, kindly see, my lord, the page number 15, last but one paragraph, ಅರ್ಜಿದಾರರ ಪರವಾಗಿ ಅವರ ನ್ಯಾಯವಾದಿಯವರು 4/2/2020 ಲಿಖಿತವಾದವನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ ಮತ್ತು ಪರಿಷ್ಕರಣಾ ಅರ್ಜಿಯಲ್ಲಿ ತಿಳಿಸಿದ ವಿಚಾರವನ್ನೇ ಮತ್ತೊಮ್ಮೆ ತಿಳಿಸಿ ವಿಳಂಬ ವಿನಾಯಿತಿಗಾಗಿ ಲಿಮಿಟೇಷನ್ ಕಾಯ್ದೆಯ ಕಲಂ 52 ಮತ್ತು 5ರಂತೆ ಅರ್ಜಿಯನ್ನು ಅಫಿಡವಿಟ್ನೊಂದಿಗೆ ಸಲ್ಲಿಸಿರುವುದರಿಂದ ವಿಳಂಬ ವಿನಾಯಿತಿ ನೀಡಿ ಪರಿಷ್ಕರಣಾ ಅರ್ಜಿಯನ್ನು ವಿಚಾರಣೆಗೆ ತೆಗೆದುಕೊಂಡು ಸಹಾಯಕ ಆಯುಕ್ತರ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಪ್ರತಿವಾದಿ 1 ಮತ್ತು 2ನೇ ಪರವಾಗಿ ಅವರ ಪರ ವಕೀಲರು 5/1/21 ಲಿಖಿತವಾದವನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅದರಲ್ಲಿ ಅವರು 4/4/2017 ಸಲ್ಲಿಸಿದ ಆಕ್ಷೇಪಣೆಯಲ್ಲಿ ತಿಳಿಸಿದ ವಿಚಾರವನ್ನು ಮತ್ತೊಮ್ಮೆ ತಿಳಿಸಿ ನೋಂದಾಯಿತ ದಸ್ತಾವೇಜು ಪ್ರಕಾರ ಪಹಣಿ ಆಗಿರುವುದು ಕಂದಾಯ ಇಲಾಖೆ ಕರ್ತವ್ಯವಾಗಿದೆ. ಆ ಪ್ರಕಾರ ಖಾತಾ ಬದಲಾವಣೆಗೆ ಆದೇಶ ಮಾಡುವುದು ಸರಿಯಾದ ಕ್ರಮವಾಗಿದೆ. ಪರಿಷ್ಕರಣಾ ಅರ್ಜಿ ಸಲ್ಲಿಸುವಲ್ಲಿ ಆಗಿರುವ ವಿಳಂಬದಕ್ಕೆ ಸರಿಯಾದ ಕಾರಣದಿಂದ ಸೋ ನಾವು ಕಣ್ಲಿಸಿ ಮೇಲೆ ಕಾರಣಗಳು. ಅಂಶ 1, ಪೆರ್ಮುದೆ ಗ್ರಾಮದ 22/1P2ರಲ್ಲಿ 25 ಸೆಂಟ್ಸು ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 22/1PL 50 ಸೆಂಟ್ಸು ಜಮೀನುಗಳ ಬಗ್ಗೆ ಮಂಗಳೂರು ಸಿವಿಲ್ ಜಡ್ಜ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ OS ನಂಬರ್ 4 of 1965 ದಾವೆ ದಾಖಲಾಗಿ ನ್ಯಾಯಾಲಯವು ಕೋರ್ಟ್ ಕಮಿಷನ್ RIA ನಂಬರ್ 697 of 66ರಂತೆ ನೇಮಕಾತಿ ಮಾಡಿದ್ದು, ಕೋರ್ಟ್ ಕಮಿಷನರ್ ವರದಿಯಂತೆ ಸರ್ವೆ ನಂಬರ್ 22/1 16 ಸೆಂಟ್ಸ್ ಜಾಗ ಮತ್ತು ಕೋಸೆಸ್ ಡಿಸೋಜಾ, ಆಗ್ನೆಸ್ ಡಿಸೋಜಾ, JD ಸೋಜಾ, ಮಾರ್ಸೆಲಿನ್ ಕೊಯ್ಲೋ ಇವರಿಗೆ ಜಂಟಿಯಾಗಿ ಮತ್ತು ಅದೇ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ ಮೆನೇಜಿಸ್ ಅವರಿಗೆ 3 ಸೆಂಟ್ಸ್, ಫ್ರಾನ್ಸಿಸ್ ಡಿಸೋಜಾ ಅವರಿಗೆ 3 ಸೆಂಟ್ಸ್ ಹಾಗೂ
related to the parties in OS.
They are the cousin brothers.
You were represented in that suit?
No, my father was represented in that suit.
Then if your father has agreed for a decree, how can you go?
Now they are claiming a right on the basis of the will executed by their father. Now, my lord, will has not, I have not given any opportunity. This order came to pass without any notice to us. Whether we are a party, whether
notice
no notice. I have specifically alleged in the appeal, my lord. Assistant Commissioner has passed an order without there being any notice.
Where is the order of the Tahsildar mutating the names?
Tahsildar, that your lordship will. No, Tahsildar has not passed any order, my lord. First time Assistant Commissioner has passed an order. Now, RTC, my lord, your lordship kindly see, I have produced the RTC.
Come to Annexure B.
Yes,
first paragraph.
ಮೇಲ್ಮನವಿದಾರರು ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ 1964 ಕಾಲಂ 136 ಬಾರ್ 2 6ನೇ ಪ್ರತಿವಾದಿಯವರ ಆದೇಶ MR ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ 17/7/2004 ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
Where is it? MR 67/2003-2004.
My lord, that is not available. I will produce, my lord. That is the order of the Tashildar. Now, lord, the assistant commissioner says on the basis of the will copy of the will has not been given to us. And
when the AG accepts notice for R3 and R4, both the parties to maintain status quo.
Yes.
In 1718. In this writ petition, an order of forfeiture passed to the Assistant Commissioner for alleged contravention of section 79 cap A and 79 cap B of the Telecast Act is under challenge. It is a case of the petitioner that she was not notified of the proceedings, and hence the order passed behind her back cannot be sustained. The order of the Assistant Commissioner does not state as to whether the notices issued to the petitioner had in fact been served, though an observation is made that notices were sent. In my view, in a proceeding in which lands are sought to be forfeit, it would be incumbent on the authorities to ensure that the persons against whom the contravention is alleged, which entails a forfeiture of the lands, are actually served. Since the impugn order does not indicate that the petitioner was served, and since an order has been passed in her absence, the impugn order cannot be sustained and is accordingly quashed. The matter shall now stand remitted to the Assistant Commissioner, who shall afford an opportunity of hearing to the petitioner and thereafter pass an appropriate order in accordance with law. The petitioner shall appear before the Assistant Commissioner on 30th of June to take further instruction in it. What is the prayer? Next, K. What is the next K? Appeal ilva adar mele. Where do you find that? Where do you find that? The appeal correct, but will an AC go against that kind of reference? Revision agate net direct hogoda. What have you done there? Illotiದ್ರೆ The documents that you produced were in relation to serial number 25, 26, and 27. What is your right over serial number 42, which is the lake? Then why are you worried if they were to evict the encroachment in serial number 42? Correct. Now, if you admit this contention in page 60, that there's an encroachment, obviously the encroachment in serial number 42. Then your argument that you purchased in serial number 33. You may have purchased serial number 33, but it appears that you have put up a construction in serial number 42. Then how are you worried? I will make it clear that if the land of yours, if the construction is in serial number 42, it won't be saved. If it's in serial number 33, then it will be saved. Sure. Now, where is it given a finding that his land is in serial number 42? His construction is in serial number 42. I asked him that question so that to see whether he'll agree. Page 65. Page 65, notice. Nimdeli objection, so Shailaja. You obtained a sanction plan also. ಎಲ್ಲಿದೆ ಫೈಂಡಿಂಗ್ ಅವರು ಸರ್ವೆ ನಂಬರ್ 33 ಅಲ್ಲಿ ಇಲ್ಲ 42 ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ? Should you not give a finding that the house that is actually constructed is in survey number 42? Because you should not use this order in the survey number 42 to demolish a structure in survey number 33. Who's to decide that? You should give a finding first, whether it's in 42 or 33. You will still insist it is in survey number 42 only. Correct. But you come to page 65. This is what he says. Further, the respondents have not produced any material documents to substantiate the rights over the lake situated in survey number 42. The report along with the sketch placed by the ADLR clearly substantiate that the respondents have encroached the different extent of land in the subject lake. When they say my land, my structure is in survey number 33, should he not give a finding as to whether it is in survey number 33 or 42? He gives a finding that it is in survey number 42. Sorry, but what is it with notice to them? How was he met their contention that in survey number 33? You should have said, I have inspected the spot or I obtained a report on survey number 33. His house is not situated there. ಯಾರಿಗೋ ಜ್ವರ ಬಂತು ಅಂದ್ರೆ ಯಾರಿಗೋ ಬರ ಹಾಕೋದು ತಪ್ಪಾಗೋದು. ಎಲ್ಲ ಫೈಂಡಿಂಗ್ ಇದ್ದಂಗಿಲ್ಲ ಶ್ರೀನಿವಾಸ್. ಅಲ್ಲ ಇವ್ರದ್ದು ಅದ್ರ ಇದೆ ಅಂತ ಬರ್ಬಿಟ್ಟಿದ್ದಾನಲ್ಲ. How can he pass such? ಕೇರ್ಲೆಸ್ ಎಲ್ಲಿದೆ? ಏನೋ ಸುಮ್ಮನೆ ಅವಸರಕ್ಕೆ ಮಾಡಿರೋದು, ಏನೋ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಲ್ಲ ಅಂತ. ಅದನ್ನ ತಪ್ಸ್ಕೊಳಕೋಸ್ಕರ ಏನೋ ಒಂದು ಲೋಕಾಯುಕ್ತ ಅಂತಾನೆ ಹೇಳಿದಾರಲ್ಲ, ಅದನ್ನ ತಪ್ಸ್ಕೊಳಕ್ ಇನ್ನೊಂದು ಆರ್ಡರ್ ಮಾಡಿ ಬಿಸಾಕೋದು. I'll have this next week. Get instructions. When a AG accepts notice for respondents, he seeks time to secure instructions. This was stated here that the contention of the petitioner was that her construction was erected in site bearing number 72, which was carved out of land bearing survey number 33 of Ulimabu village. And she had put up a construction after obtaining necessary sanctions from the competent authority, and after the land was converted under the orders of an order of the deputy commissioner. These are a specific case that her land is not relatable to land bearing survey number 42, which is said to be a lake. Next one. The Tahsildar in the impugn order does not record a finding as to whether the house of the petitioner, the structure erected by the petitioner, is situated within survey number 33 or survey number 42. He makes a sweeping observation that the sketch of the ADLR indicates that the petitioner has encroached the land which is earmarked for, which is classified as a lake. In the absence of a specific finding regarding the location of the petitioner structure, the impugn order, prima facie cannot be sustained. There shall therefore be an interim order of stay of all further proceedings pursuant to the impugn order insofar as it relates to the petitioner Shailaja Gopal Kulkarni till the next date of hearing. Communicate ಮಾಡಿ ಅವ್ರಿಗೆ ಮಿತ್ರ ಅದನ್ನೇನು ಮಾಡೋದು ಬೇಡ. ಶೈಲಜಾ ಅಂತ ಅವ್ರದ್ದು ಹೇಳಿದಾರೆ. There's a reference to the order in the order. But ಆದ್ರೂ she has appeared in ಹೇಳ್ಬಿಡಿ ಅವಳ ಎಮ್ಮಂದ ಸರ್ವೆ ನಂಬರ್ 33 ಅಲ್ಲಿ ಇದೆ ಅಂತಂದ್ರೆ ಐ ಕ್ಲೋಸ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. And give him a copy of the sketch, ADLR sketch, ಕೊಡಿ ಅವ್ರ copy.
35 might appearing for the petitioner counsel.
Yes.
There are 3 items of property which are subject matter of excise arrears, where my lord was subject auctioned and the confirmation process was commenced. Then we filed an objection stating that at the instance of the landowner, a suit is pending before the civil court in OS 109 of 2005.
136 proceedings is 136 proceedings.
136 proceedings. Suit to decree agide. Our state have filed an appeal against the decree. It was dismissed. An appeal was dismissed for non-prosecution. Miscellaneous application was filed. That was also dismissed. Auction purchaser have filed a regular appeal. That was also dismissed. He filed miscellaneous application for restoration. That was also dismissed. Now, after all these things, when the entry sought for alterations based on the decree, they accepted our case. But Assistant Commissioner says mutation was effected on the basis of confirmation order by the Deputy Commissioner. Therefore, I have no jurisdiction. I can't do it. Deputy Commissioner says in revision, it is a public auction. It is confirmation. Therefore, I don't want to alter the entry.
The suit was against the auction purchaser also.
Auction purchaser as well as the state.
You know, when an AG accepts notice for respondents 1 to 3, issue notice to the other respondents. There shall be an interim stay of all further proceedings pursuant to. ಯಾವ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ನೀವು?
I have challenged the
appeal
order.
ವಜಾಗಿದೆ, ರಿವಿಷನ್ ವಜಾಗಿದೆ. ಯಾವ ಆರ್ಡರ್ ಮತ್ತೆ ಸ್ಟೇ?
And mutation entries na stay ಕೇಳಿದ್ದೀನಿ. Annexure B stay ಮಾಡೋದಕ್ಕೆ. Annexure B. I sought for stay of.
They shall status quo regarding entries be maintained.
Status quo ಅಂದ್ರೆ ಏನು ಉಪಯೋಗ ಆಗದೆ?
ಮತ್ತೆ ನಾನು ಯಾವ ಆರ್ಡರ್ ಮೇಲೆ ಮಾಡಲಿ? ಇಷ್ಟು ದಿನ
I sought for, may kindly see the player at page 17 ಮೇಲೂ.
ಅಲ್ಲ AC ಮುಂದೆ ಸ್ಟೇ ಇತ್ತಾ?
AC ಮುಂದೆ we had the benefit of interim order, of course.
The interim order was in respect of what?
Yes, entries in further proceeding pursuant to the entries. In
No.
RRT SERA 709 of 07 and 8, as well as Annexure
Annexure?
H and P.
Annexure?
Annexure B. Annexure B
Stay
at
of all
page
further
23.
proceedings pursuant to MR 2/07-08. Capital Annexure B and H. (92) order. You are landlord or tenant? Your name is Srinivas. In Tandena? Govindappa. Govindappa. Your father is Govindappa. Where? We have sought to reduce the extent now. Yes, Srinivas? Issue notice when the AG accepts notice for respondents 1 to 3. This will be interim stay of all further proceedings pursuant to Annexure H. ನೋಡಿದ್ದೀರಾ? Get instructions. Now you want to get instructions or you want me to instructions ತಗೊಳ್ತೀರಾ? ಅಲ್ಲ, who has encroached? What is your claim over this land? What is there to show that there is a road in the village map? No, 29 is a photograph. Is there a road indicated in the village map? Take instructions. When a AG accepts notice for respondents, he seeks time to secure instructions. Relist on 30th. ನಿಮ್ಮಲ್ಲಿ ಅಪೀಲ್ ಇಲ್ವಾ ನಿಮ್ಗೆ? ಕೇಸಿಗೆ ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕೋದು? ಕರೆಕ್ಟ್. ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ಗೆ you secure instructions and grant a stay for a few days. Then a DG accepts notice for respondents. He seeks time to secure instructions. Released on 30th. There shall be an interim stay of all. ಅಲ್ಲ ಹೊರ ಹಾಕುವ ನೋಟಿಸ್ ಅಂತ ಹಾಕಿದ್ರು. ನೀವು ಈ ನೋಟಿಸ್ ಪಡೆದಿದ್ದರಿಂದ ದಿನಾಂಕ 7 ಖುಲ್ಲಾ ಮಾಡಲು ಈ ಮೂಲಕ ಕೋರಲ್ಪಟ್ಟಿರೋದು. It's been asked to hand over project. This is an interim stay of all for the proceedings pursuant to Annex LG till then. Find out because ಏನಂತ ಆದೇಶ ಅಂತ ಬರೀತಾರೆ. ಒಂದು ಆದೇಶ ಪತ್ರವನ್ನು ಮಾಡಲಾಗಿದೆ. Find out what is that order. Maybe he'll have to file an appeal against that order. ರೆಡಿಯಾಗಿ ಅಪೀಲ್ ಹಾಕೋದಕ್ಕೆ ಮಾಲ್ ಕೊಟ್ಟೆ. Two-third. 2011 country 11-year-old matter. I will not grant it. ಓದ್ಕೊಡಿ ಅಷ್ಟು, ನೀವು ಓದ್ಕೊಡಿ ಅಷ್ಟು.
My lords, I appear for respondent number 4C and respondent number 5, my lords. I'm reporting the death of respondent number 4B and respondent number 6, my lords.
Who are they?
One is respondent number 4B is the legal ಒಬ್ರು CT ಮುನಿಸ್ವಾಮಿ ರೆಡ್ಡಿ ಸ್ವಾಮಿ, ಇನ್ನೊಬ್ರು 4B ಶ್ರೀ N ರವೀಂದ್ರ ರೆಡ್ಡಿ.
Who's dead? R4B na?
Respondent number 4B.
No, he is served. Therefore, there is no need to take steps against him. And is remained under present. Who else? Ravindra Reddy and then?
Respondent number 6, my lord, CT Muniswamy Reddy.
What is the order impugn?
Petitioners on the one side, respondents 4 and 5 on the other.
6 and bedva. Who's R6 then?
R6 is the brother of the petitioner.
Okay, R6 nim brother atan he does he have any?
Memo that is given to me. Respondent number 4B. 4B is the mental.
Correct, but R4B has been served.
R4B
No, R4B in Ravindra Reddy is served. Then if he served and it does not.
4B, she ready to receive.
Sorry, if he is dead and if he has remained served and unrepresented, there is no need to take steps against him. R6 formal party tana.
R6 formal party sealing with the petitioners. The petitioners 80 days. Can you speak there?
What is the main matter?
The matter of the subject matter of the survey number 99/5 of this village. Ichanganur village, Nativere Hobli. 99/5 is the survey number in question.
Survey number?
99/5. 5 Puntas is its extent. 5 Puntas is its extent. There is a statement of the year 1955.
What was the order that was challenged before the Assistant Commissioner?
Under the 55 cent. Petitioners order Chikka Pimari showed several survey numbers in favor of defendants 4 and 5. But survey number 99/5 is not the subject matter of that shading. That's on the basis of that shading. Defendants, respondents 4 and 5 moved their Tashildar or Kasa claims in their favor. That's though the survey number was not there. But Kasa was made in their favor with respect to this survey number. That's all. Coming to know of that. That's I filed an appeal before the Assistant Commission. The assistant commissioner after going through the stating, notice that survey number 99/5 is not the subject matter of the stating. Therefore, making of Khata with respect to 99/5 will Tashikar or not correct. Therefore, he allowed the appeal. But there was certain delay in filing the appeal, for which an application for consideration of the delay had been filed. The assistant commissioner, after noticing a decision of this honorable court, where unjust order is possible, making of Khata with respect to a survey number which is not included in the statement, condoned the delay and allowed my appeal and set aside the mutation number. That's the revision petition is filed by respondents 4 and 5. The deputy commissioner says the assistant commissioner was not justified in condoning. That was the only reason so given by the deputy commissioner.
What was the delay?
The included order of mutation order of year 72. That's I filed the approval of the 5-6.
Then don't you think it's justified after so many years? An entry which stood for
But then the mutation order, let's take the term to the mutation order itself. Modalu safety to zero survey number 1 is the order ಮಾಡಿದೆ. ಈ survey number subsequent ಆಗಿ
ಸರಿ ಕರೆಕ್ಟ್. ಬಟ್ ನೀವು ಅಷ್ಟು ವರ್ಷ 28 ವರ್ಷ ಪ್ಲಸ್ 5 33 ವರ್ಷ ಸುಮ್ಮನೆ ಕೂತಿದ್ರ.
ಆ ಶರ ಅಂತ ಮಾಡಿ ಅದನ್ನ ಆಡ್ ಮಾಡಿದ್ರು.
ಕರೆಕ್ಟ್. ಬಟ್ ನೀವು 33 ವರ್ಷ ಸುಮ್ಮನೆ ಕೂತ್ರಲ್ಲ.
Is that a genuine ಶರ?
But it stood for 33 years.
ನಿನ್ನ ಕೈಲಿ ಕಂಡು ಮುಟೇಶನ್ order.
Next year.
Page 21.
Page 21.
I had it out.
Mostly ನಂಗೆ ಸೇಲ್ ಲೀಡರ್ ಪೇಜ್ ನಂಬರ್ 21 ಅಂದ್ರಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಎ ಇಸ್ ದಿ ಸೇಲ್ ಲೀಡ್.
ಅದರಲ್ಲಿ ಆ ಬಾಕಿ ಸರ್ವೆ ನಂಬರ್ 1 ಸಾಲ ಮಾಡಿದ್ದಾರೆ 69.
ನಾನು ಒಪ್ಕೊಳ್ತೀನಿ ಅದು ಸೇಲ್ ಲೀಡರ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. ಬಟ್ ಕ್ಯಾನ್ ಯು ಕೀಪ್ ಕ್ವೈಟ್ ಫ್ರಮ್ ಪೇಜ್ ನಂಬರ್? ಇಲ್ಲ ಪೇಜ್ ನಂಬರ್
ಪೇಜ್
21 ಸೇಲ್ ಲೀಡ್. ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಎ ಸೇಲ್ ಲೀಡ್ ಪೇಜ್ 19 ಇಂದ ಶುರು ಆಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಬಿ. ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಬಿ RTC. ಮೋಸ್ಟ್ಲಿ ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಸಿ ಇರಬೇಕು. ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 1894 ಅಂತ ಹೇಳ್ತಾ ತಾನೆ.
ಅದರಲ್ಲಿ ಬಲಗಳಿಗೆ ಬಂದ್ರೆ ಕೆಳಗೆ ಅಲ್ಲಿ ಒಂದು ಶರ ಅಂತ ಆಡ್ ಮಾಡಿ ಲೈನ್ ಸೇರಿಸಿ.
ಏನ್ ಹೇಳಿ 90 ನಂಬರ್ಗೆ ಖಾತೆ ಇರುತ್ತೆ, ಮಂಜೂರಾಗಲು ಅರಿಕೆ 99/5 ಇಲ್ವಲ್ಲ ಮ್ಯೂಟೇಶನ್. ಅಲ್ಲ ಏನಂತ ಹೇಳ್ತಾರೆ ಶರ 99/5ನೇ ನಂಬರಿಗೆ ಖಾತೆ ಇರುತ್ತೆ, ಮಂಜೂರಾಗಲು ಟೈಪ್ ಕಾಪಿ ನಂಗೆ ಬರುತ್ತಪ್ಪ ಖಾತೆ. ಸರಿ, ಬಟ್ ಇದನ್ನ ದಿಸ್ ಇಸ್ ಆಫ್ ದಿ ಇಯರ್ 68-69. ಎಲ್ಲಿದೆ ಡೇಟ್? ಎಲ್ಲಿದೆ ಸಪರೇಟ್ ಆರ್ಡರ್?
25-72
ಏನು ಅರ್ಥ? ಸಬ್ಮಿಟೆಡ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟಿವ್ submitted in respect of number 99/5 ಅಂತ ಇದೆ. ಸರಿ, ಬಟ್ ಇಟ್ಸ್ ಬೀನ್ ಇನ್ ಫೋರ್ಸ್ ಫಾರ್ ಹೌ ಮೆನಿ ಇಯರ್ಸ್ ನಾವು? ಒಪ್ಕೊಳ್ತೀನಿ, ಬಟ್ ಆದ್ರೂ ನೀವು 30 ವರ್ಷ ಸುಮ್ಮನೆ ಕೂತ್ರಲ್ಲ. What is your claim over this survey number 99/5?
My lords, may make one submission, my lords. This respondent number 6 is a necessary party, my lords.
But I will decide. Your entitlement is regarding 99/5. What is your claim for 99/5? Odilva?
My lords, ready, it may be had tomorrow, my lords. I shall argue the matter, my lords.
Nalega kotu. If you don't have a sale lead in the 99/5, then difficult to maintain your entry
All right, my lord.
tomorrow.
Say 94 or 7. Read that as 99/5.
Odilva, I don't know to dismiss it.
Obliged, my lord.
I have written evidence marked nearly 25 documents, including the written statement filed by the respondent, wherein Malad himself has admitted that I am the tenant. But these facts have not been considered by the by passing an order. Then what it can be remanded.
An order, I will enter rejecting the claim of the petitioner as a tenant is challenged in this writ petition. Shri Harish, do not consider the petitioner places reliance on the fact that in OS 763/62, which has been filed by one Quantum Chaudappa against the
Petitioner and respondent. Timmanagowda, Basappa.
against the father of Basappa, against the father of against the Dortimappa is the father of the first applicant. But shouldn't the tribunal consider this at all? I am recording this contention that he placed reliance on this. This has not been considered, therefore I am sending it back. That is his argument, isn't it?
All the documents, both the parties be given as the land.
Like as for the petitioner places reliance to the fact that in OS number 762,
which was a suit instituted by one Quantum Chaudappa against the deceased petitioner. Deceased petitioner is petitioner. Then Tammanagowda, son of Kariyappa anta ide. And against the landlord Tammanagowda, and also the tenant, that is the petitioner's hearing. And the said suit was for declaration and for possession, for partition. And in that said suit, the landlord himself had filed a written statement in which he had admitted that the land was in possession of Basappa, the tenant, and who had been arraigned as a second defendant in the suit. He submits that this admission of the landlord at an undisputed point of time clearly establishes that the land was tenanted and the petitioner was the tenant. He also submits that despite the production of the written statement and other documents relating to the suit, the land tribunal has not even considered the same, and therefore the order cannot be sustained. The reading of the order of the land tribunal goes to show that the tribunal has not considered the effect and purport of OS 763/62 on the claim of the petitioners. Since the tenant places reliance on a written statement of the landlord in which his alleged tenancy is admitted, it would be imperative for the land tribunal to consider the same and pass appropriate orders. Since this has not been done, the impugn order cannot be sustained and the same is set aside. As for the land tribunal, the matter should stand remitted to the land tribunal. In the land tribunal, after giving both the parties an opportunity of having their say regarding the proceedings in OS 763/62, pass appropriate orders in accordance with law. It is open for the landlord to put forth any contention that he so desires to counter the governments of the tenant regarding the filing of OS 763/62. That is why I said I am leaving open all contentions for you to plead before the land tribunal to counter OS 763/62. That is why I've said it's open for you to put forth all contentions that you so desire to counter OS 763/62. Both the parties entitled them. That's what I've said. Both the parties. I think it's comprehensive. If you want. It's a lot. It's better.
In fact, they are party to the same thing. Petitioners to the lordship. They also support witness on the other.
Whom do you appear for?
Respondent number 6. And also
Rugna D'Souza. Rugna D'Souza. You are not a party to this order.
One more impeding applicant. He has purchased from these petitioners. That's why they are not input into the petition process. Parties with respect to survey number 352.
ಸಲ ಕೇಳಿ ವಿಚಾರಿಸಿ ಸುಮ್ಮನೆ tell them morals I will allow the petition ಅಂತ ಹೇಳಿ then they'll come. Tell them that I'm going to allow the repetition. If they don't come and give you instructions, they will suffer the consequence. I cannot take cognizance of this compromise to which you are not a party. This is a compromise between the petitioner and somebody else. And I'm not very sure as to what is the land involved and what is the compromise. There are two suits, only one suit. What is your client's name? Because here he says the plaintiffs admit that the title of Mr. Sai Radha Developers over the properties acquired under the sale deed described in the list below, executed by Judar D'Souza, Joseph D'Souza, Mary D'Souza, Benedict D'Souza, Philomena, and Paul D'Souza. You are not there in that sale deed.
They are not responding.
See, until he says dismiss the petition as withdrawn, or as said, I cannot on the basis of your statement accept. That's why don't press this memo. If he says that they're not parties, I cannot take cognizance of this. Leonard Counsel for the respond number 3 submits a memo in which a compromise decree is enclosed, stated to have been entered by the petitioners. She Narayan Swamy requests for time to secure instructions. This matter next Wednesday. 2010. If you can get it within 1 week, you can get that also within a week. 2013 Mr. Sambat, or else I wouldn't have. I'll give it for 1 week. Let us see after 1 week. Make efforts. Next week. I'm marputting and Salatriga fractured.
The application filed by appellant has been rejected by committee on 25/7/1994 for the reasons so and so. Hitler, issue number 1.
The application filed with the appellant has already been rejected by the committee on 25/7/94. The reasons that the suit that she is a sufficient holder.
I will address the court from the beginning itself. The petitioner.
Who was the appellant there? Meenakshi.
The petitioner herself. I will explain. Annexed A is the accused order license. Annexed A is the accused order passed by KD wherein the application for grant of land under Akrama Sakram filed by the respondent contesting the respondent number respondent number 2 was accepted. The application filed by him is at annexure Melons.
No,
Annexure D, page number 39.
339 bar 4.
339 bar 4B1. Another case, the grant was for 393 for 4B1. Whereas my application at annexure D, page number 32.
But this claim was rejected.
That is what the court wanted me to clarify. Plus, kindly look at the date of annexure B Melon. That is 27/4/1999. The order which your lordship just now read, that is the annexure G, page number 52, date refers to 1994, probably must have been the earlier application, where the grant of Unkiland was
No.
not.
The DC had dismissed your appeal on 4/7/2007. Page 49. What was the challenge before the Assistant Commissioner? What was the challenge?
It's very same order, my lord. What had happened, my lord? The deputy commissioner, although dismissed my appeal, had directed the Tahsildar to give report. By mistake, my lord, this order was not challenged. The petitioner considered this order as in her favor because of the age factor and other.
Yenge.
That was challenged by me before the KAK later point of time with the delay condition, which was allowed and ultimately on the merits it was dismissed. That is different. Now that is.
No, if that is a fact,
Please,
that this order of the Deputy Commissioner
please,
was confirmed by the Karnataka Appellate Tribunal,
please.
your claim for regularization came to an end.
ಇಲ್ಲ. ಈ ಇದಕ್ಕೆ challenge ಆಗೋದು ಅವ್ರಿಗೆ ಕೊಟ್ಟಲ್ಲ ಇಲ್ಲ.
Correct. ನಿಮ್ದು claim ಹೇಳಿ, ನಿಮ್ದು claim ಹೋದ್ರೆ
ನನ್ನ claim ಹೋಗಿ. I requested the court to look into the date when it was 27/4/1999.
no, Mr. Sherry, please come to page 52 once again.
52, my lord, please.
This was a claim that you made in respect of land bearing survey number.
393 ಅದಲ್ಲ ಇದು ಅವರ ಗ್ರಾಂಟಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತ ಅಪೀಲ್. ನನ್ನ ಗ್ರಾಂಟಿಗೆ ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. There are two parallel applications. Final claim. My application is pending and this application was allowed. That is under challenge through in all these proceedings, whatever before the court, papers before the court, is the challenge made by the petitioner in an attempt to cancel that grant.
But in page 52, he refers to a rejection of your application on 25/7/1994.
Please,
This is obviously in respect to the very same land.
very same time, but second application has been filed.
Once your application is rejected and confirmed right up to the Karnataka Appellate Tribunal. ಸರಿ ಬೇಡ ಅಲ್ಲಿಗೆ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಸಪೋಸ್
ಕಮಿಟಿಯಲ್ಲಿ ಬಿಟ್ಟೋದಲ್ಲ ಅದರ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಲಿ.
25/7/1994 your claim is rejected, against which you prefer any appeal. So if you are not preferred any appeal, your claim over this land comes to an end. To whomever it is granted is of no concern to you.
ಅದನ್ನೇ ಈ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು ನಮ್ಮ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಅದೇ ಲ್ಯಾಂಡಿಗೆ ಹೋಗ್ತದೆ.
ನಿಮ್ ಕನ್ಸಿಡರ್ ರಿಜೆಕ್ಟ್ ಆಗೋಗಿದೆಯಲ್ಲ.
ಇಲ್ಲ ಸೆಕೆಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಆಗಿಲ್ಲ.
How can you maintain a second application?
That was under Akrama Sakrama in the earlier. Now when the Unki land was allowed to be granted, that is the new new scheme formulated by government for confirming the Akrama Sakrama in respect of Unki land. That is the reason why the second application came to be filed.
Show me the first order. The first order of rejection. Then, where have you said in the petition that you had made an earlier application that was rejected, and thereafter, by virtue of this amendment, you had a second right to file an application? Where have you disclosed? Then I will dismiss it on that ground. You cannot take us for granted, isn't it?
My submission, this particular application.
Should you not have disclosed that fact,
Which one?
that your earlier claim was rejected, and you got a right by virtue of an amendment to make a second application, and accordingly you have made a second application?
That particular issue is not the subject matter of the dispute. All that my submission before the court was.
I will hold that your claim was rejected, therefore you have no locus standi to challenge the grant in favor of the petition, in favor of the respondent. That is all.
No, I ಇನ್ನೊಂದು application without enquiry ಹೋದಾಗ
That is the point. I want to do that. How can you do this? You suffer an order of rejection, keep quiet, then you claim that there's an amendment which gives you a right to file a second application, suppress all the facts before this court, and expect your second application to be revived and considered on merits.
No, that's it. The second application is not barred by any law.
I will consider that and say it is barred by law. Without having challenged the first application, you could not have made a second application.
That is one part of the argument. Another part, my lord, the land which was claimed by the second respondent, as I submitted before the court, is some other survey.
That is on the merits. That is on the merits of the claim.
Please, and more important, no notice was issued to me while taking away the Kumki right given to me. Under both standing orders of 1888, my lord, this particular Varga
I
line.
am still unable to get over how you will overcome the order against you. All the arguments you have been advancing are on the merits. If your claim is rejected, matter comes to an end.
Even assuming that what the court said is accepted by the petitioner, but my second line of argument would be, if I am having a cookie privilege over certain land, while taking that land, while granting it to somebody, well, it is necessary to give me notice.
By rejection of your claim, you lost all rights to object, to claim, everything is lost.
No, my lords, I have claimed ownership by virtue of filing application for grant of the Akramas account.
What is the effect of the rejection?
Rejection means I have not declared as owner. That's all. My Kumki right has not been taken up. Third, my possession is there under the board standing orders.
Or it's already furnish the order rejecting your application. Let us see.
I will do that.
We list next Wednesday.
Number 45.
News will notice us. Ready na? ಅವ್ರದ್ದೇನು ರೋಲ್ ಇಲ್ವಾ ಸರ್ಕಾರದ?
Cancellation of the grant after 40 years. And after argument, the court has specifically made an order to the state to make their stand. Because there was an order passed by the Judicial Commission of Karnataka. Last time, what my brother said, another concept. He said he will file objection as directed to the court.
ಅವ್ರನ್ನ ರಿಸೈನ್ ಮಾಡ್ಬಿಟ್ರಂತ ನೆನ್ನೆ ಅದಕ್ಕೆ
He will not have
2 weeks.
We have been equal efforts. And the other concept, the argument, more than once.
When is it order? Stay direct to objections. Srinivas, 24/9/2021. The state is also directed to file objections and make it stand clear regarding the issue whether an order has been in fact passed by the divisional commissioner or not. Next Wednesday. Finally, we list on so and so to enable the state to file its objections.
before the regrant and ultimately this for demand
So the tenant to demonstrate that he was in occupation as a tenant prior to the date of vesting, which is 1/2/63, and that he had continued in occupation as a tenant for the purpose of the Land Reforms Act as on 1/3/74. Now, what has the land tribunal said? That you have not established that you are in possession. Page 47 is the reasoning. Page 47. What is the reasoning of the land tribunal at page 47? Internal page 5. In favor of the purchaser, Mohan. Yes. Please read from page 5. ಉಭಯತರು ನಿವೇದಿಸಿದ ಅಂಶಗಳ ಹಾಗೂ 47, internal page 5 of the order matter. Now, your application is under the village office abolition act initially. So you will have to first establish. Now we will ignore that order of regrant for a minute. Now, how do you establish that you are in possession as on 1-2-63? Now, even this tribunal holds that the revenue entries stand in your name for the period. Now we are concerned with 1-2-63. All right, we will forget about the point. Is what else is there to show that you are in possession as on 1-2-63? Now that is subsequent 87. That's another thing. Your initial claim, Mr. Krishnamurthy Anand, is that you are in possession as of 1-2-63. You will have to establish that. There can't be a presumption that you are in possession. But for how many years backwards? In whose time did the revenue record stand for the year 63? And revenue record Silva 60-63 dirham. Where is your statement that you are in possession? And where is this Muchalike? This is the account of year 84. You appear to have settled your claim. You have taken some money and done this. Why would anybody, especially after a tenant had succeeded before the land tribunal, he admits that. ತಗೊಂಡು ಆಮೇಲೆ ಈಗ ಸೆಕೆಂಡ್ ರೌಂಡ್ ಅಷ್ಟೇ ಇದು. ಇಲ್ಲ ಇದು ಸೆಕೆಂಡ್ ರೌಂಡ್. Rightly or wrongly, you agreed for a settlement one way or the other. You must have been satisfied the day you executed this 84. Now, if you want to revive the claim, it would be unfair. ಇನ್ನೇನೆ ಎಕ್ಸ್ಟ್ರಾ ಬೇಕು ಅಂತಾನೆ ಇವಾಗ. ಏನಾರು ರೀಸನಬಲ್ ಕ್ಲೇಮ್ ಇದ್ರೆ ಕೇಳಿ ಕೊಡ್ಸ್ಕೊಂಡು ಲೆಟ್ಸ್ ಕ್ಲೋಸ್ ದಿಸ್ ಮ್ಯಾಟರ್. Or else I am prepared to dismiss it right now. 10 days in next Wednesday. If you don't settle, I'll dismiss it. Next Wednesday. I just want him to get a chance to settle with you by taking some money, or else I'll close it next Wednesday. If you are generous and want to buy peace, settle it. You will let him withdraw the requisition. Thursday. Yavat begin. Tuesday, 14th. Tuesday ಅಂತ Wednesday ಅಲ್ಲಿ ಹೋಗಿದ್ವಿ. Monday. I'm not disabled. In ಬರ್ತಾರ ಅವರು ಎನ್ ಕುಮಾರ್. Page 50. The challenge here is to the order of the assistant commissioner and
The assistant commissioner order is my favor. The DC order, that page 69 is
you made an application to enter your name.
what happened was I used to impression of facts. My hand was notified. Soon after
Your brother challenged it first and
my
thereafter.
brother challenged, but his time was released. So far as my land is concerned, it was detailed. Then another big petition was filed. So the report was issued, washed the notification. So far as my land was concerned.
Next E.
Meantime, revenue records to be rotated to input to government, which is what I sought to reverse not and that was allowed by virtue of the AC order, that page 46. That order not was questioned by the respondent before the object, which resulted in the equal order at page 69.
Anyway. The Special Deputy Commissioner for Finance Abolition on 29th of April 1967, in case number 52/5960, was pleased to register Narsimaya, your father, the father of the petitioner, as a permanent tenant in respect of serial number 36, measuring 34 guntas, under section 5 of the Mysore Personal Miscellaneous Finance Abolition Act. In the course of his order, the Deputy Commissioner took notice of the admission by the objectors that the land was not a Sarkari Gundu Top, but was a private top of the petitioner, and it was not a communal land reserved for the benefit of the village community. So the Deputy Commissioner also noticed that documentary evidence had been produced to prove that Narasimhaya had purchased the property bearing number 36, and the objectors had also admitted that Narasimhaya had planted the trees. In other words, a clear finding was recorded while registering Narasimhaya as a permanent tenant that the land in question, that is number 36, was not a Sarkari Gunduto. On the death of Narasimhaya, the property was divided between his sons Venkatramaya, bracket petitioner, and his brother N. Sitaramaya. The land of the petitioner and his brother was notified for acquisition under the provisions of the Karnataka acquisition of land for grant of house sites. This acquisition was challenged both by the petitioner as well as by his brother in WP 21699/1980. This court, by an order dated 9th of September 1987, set aside the acquisition in relation to the land owned by the petitioner's brother, that is in respect of 17 guntas, and upheld the notification in respect of the petitioner's share. Subsequently, since the land had remained unutilized, the petitioner preferred WP 13798/2000, seeking for a declaration that the acquisition was bad in law. This court, by an order dated 18th of January 2006, allowed the writ petition. 18th of August 2006, allowed the writ petition and quashed the notification dated 11/3/1977 in respect of the petitioner's extent of 17 guntas also. Liberty was reserved to the authorities to initiate fresh proceedings if need be in accordance with law. It is stated that no fresh proceedings were initiated and the land therefore stood restored in favor of the petitioner. However, since revenue entries continued in the name of the authorities, the petitioner made an application for restoration of his name by making an application to the Assistant Commissioner. The Assistant Commissioner, by an order dated 3rd of February 2014, which is produced as Annexure G, allowed the request of the petitioner, directed the Tahsildar to enter the name of the petitioner in respect of 17 guntas in survey number 36 of Eggadadevanapura village, Dasanpura Hobbli, Bangalore North Taluk. This order was challenged by the fifth respondent by filing a revision. It was the contention of the petitioner that the land in question was a Sarkari Gundu Topu and the revenue entries could not have been made out in favor of the petitioner. The petitioner entered appearance and filed detailed objections, highlighting the fact that the Special Deputy Commissioner in the year 67 itself, had found that the land in question was not a Sarkari Gundu, and the petitioner was entitled, and the father of the petitioner was entitled to be registered as a permanent tenant. Next one. The Deputy Commissioner, however, by the impugn order, has come to the conclusion that the land bearing survey number 36, measuring 17 guntas, was
relook at the issue.
Has directed the Assistant Commissioner to ascertain as to whether the lands in question were in fact the private holdings of the petitioner, and thereafter proceed to pass fresh orders. Next paragraph. The Deputy Commissioner, despite being informed that a clear finding had been recorded that the land in question was a private land way back in the year 1967, has fundamentally ignored this plea and has remanded the matter for holding of an inquiry. In view of the fact that way back in the year 67, the Special Deputy Commissioner for Enam Subrogation himself recorded a finding that the land bearing sub number 36 was not a Sarkari Gundu Topu, but was a private Topu of the father of the petitioner, the question of holding an inquiry afresh in the year 2018, and that too at the behest of villager, cannot be sustained. The fact that the lands in question were notified and subsequently the acquisition was declared to be bad in law also re-emphasizes the fact that the land in question was never a Sarkari Topu. If in fact the land had been a Sarkari Topu, the state would not have notified it at all. In the light of the fact that the lands were notified and the further fact that the notification was quashed, clearly and conclusively establishes that the land of the petitioner measuring 17 guntas in sub number 36 can never be construed as the Sarkari Topu. In that view of the matter, the order of the Deputy Commissioner, setting aside the order of the Assistant Commissioner and directing the holding of an inquiry, cannot be sustained, and the same is quashed. The order of the Assistant Commissioner, dated 3rd of February 2014, shall stand restored and shall be given effect to immediately, with petitions accordingly allowed. Forthwith ಅಂತ ಹೇಳಿದೆ. Next week. Interim order should stand extended to next week. Yes, Lord. Okay. All right. Four acres is granted to you now?
Earlier, I was granted 10 acres of land.
No, but he appears to say now that it was never granted to you.
It was granted to me, I was in enjoyment of the property.
Where is the rejection? Where is the rejection? Where is the rejection? Because you have said, after verification of the request of the petitioner, the said request has been rejected based on the fact that the land sought by the petitioner belongs to forest department. Where is the order of rejection? First paragraph, note. No, it is said it is rejected. If it is rejected, then he has the right of an appeal against the order of rejection. Rejected.
I was not rejected. Was granted 10 acres of land.
Where is that?
Page number 18. Additional documents are produced. The grant certificate here are produced. The grant certificate also. The grant certificate. Additional documents.
When did you make it? 9th of June, huh?
Yes, Lord. 7th of June.
7th of June.
I have produced the RTC. Page number 18 of the RTC. State forest 10 acres.
Page number?
Page number 18.
State forest up to
10 acres. Is 10 acres. Is the 10 acres because earlier granted to me.
Where can I get that?
Yes, sir. I have also produced that. 14/1/2022. Additional documents.
Also 14/1.
14/1.
Ilwala. 14. 12.
It was granted to me, 10 acres was granted to me, and when I was in enjoyment of the property,
Have you filed this affidavit on 8/12/2021? The affidavit told him affidavit of Nagaraj Tahsildar. I state that the lands which were granted to the petitioner on the earlier occasion are notified as forest land. As such, the grant procedure could not be completed and possession was not delivered to the petitioner. No, your contention is contrary. You are admitting in the affidavit that the land was granted but was not completed. The affidavit nodi onsala mechme. Page number?
Before the content proceeding.
Wait.
Before the content proceeding. Page number 81. Paragraph number 8. The order of this wonderful court. Paragraph number 8. It is right that no forest land can be granted. However, in circumstances, this court deems it appropriate to direct the petitioner to file an application seeking allotment of forest land within a period of 4 weeks from the date of order. If such an application is filed, respondents should consider the same and take necessary action, keeping in mind the direction issued by this honorable court in this case for it. So, that the earlier direction directing them to grant. And if the land sought by the petitioner is not suitable for allotment, suitable alternative land shall be allotted without insisting for any further application, representation from the petitioner. Such an exercise shall be done in an expedite manner, preferably within a period of 3 months from the date of receipt of the application. But subsequently, they did not take any action, they did not abide by this order.
So you sought for grant of an alternative land. No, you sought for grant of an alternative land.
Yes, ma'am.
So you gave up your claim over the forest land.
Yes, ma'am. Alternative land was directed by the alternative land.
Correct. So therefore, the claim over the forest land is gone.
No, forest land is over. That I'm not insisting now.
So this survey number
39 is over.
26 is over.
39. 39 was forest
No,
land.
in this writ petition, what was the claim about?
In this petition, I am asking survey number 26. Survey number 26. Wherein what? 517 acres of land is there. Well, I'll come to that point. Next.
So your claim for survey number 39 is over.
39 is over now.
And
Now,
you were permitted to make an application for allotment of an alternative land.
alternative.
And
It was made, and they will ask, under survey number 26, it will be allotted. Subsequent to the order of the Congress court, they just said, then no action was taken.
so you filed a
So now
contempt.
I filed a contempt petition, which is an order of contempt. Right? Page number 99. The normal kindly come to page number 101. At paragraph number 3. The counter of
5 acres of land, 5 acres of land has been granted.
Yes, sir.
That is the survey number?
That is where the false affidavit has been filed. Page number 101, paragraph number 3. A counter affidavit is filed by the accused who was working as DC.
Where is the counter affidavit? Where is that counter affidavit? Have you produced it?
For the contempt petition.
Yeah, have you produced it here?
I have that. I have one minute. He has tendered an unconditional apology for the delay in complying with the order of the land single day. He has also enclosed R1, which indicates that 5 acres of land has been granted in the terms of the schedule mentioned therein. But the very next page, this was not dated the 8th of August 2018. After this order was passed, after he files a false affidavit, tendering an unconditional apology for this honorable court to save his skin on the contempt petition. Later, subsequently, in 7/9/2019, the very next page, page number 103, 7/9/2019, he allots 5 acres of land to me, wherein what? The second paragraph to the bottom. ತತ್ಸಂಬಂಧ ಉಲ್ಲೇಖ 1ರ ಪತ್ರದಲ್ಲಿನ ಮನವಿ ರೀತಿಯ ಕಡತ ಪರಿಶೀಲಿಸಲಾಗಿ 500 ಒಬ್ಬಿ ಮಂಜರಿಕೊಪ್ಪ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 26ರಲ್ಲಿ 485.15 ಎಕರೆ ಜಮೀನು ಪೈಕಿ 5 ಎಕರೆ ಜಮೀನು ಮಂಜೂರು ಸಂಬಂಧ ಉಲ್ಲೇಖ ಪಡಿಸಿದೆ. So he takes away survey number 39 takes away 10 acres of my land and alternative allotment. In the survey number 26,
but in the contempt petition, in paragraph 5, it is said.
yes, correct. I agree with that.
So you accepted only 5 acres now. Because in the contempt, this court said there was no objection to grant 10 acres. 5 acres is to be granted.
No doubt, paragraph number 5 it is there.
So 5 acres is not.
That was on the false affidavit.
Where is the affidavit? No, but nevertheless, even if the affidavit was filed before this order was passed, the fact remains that the affidavit was given effect to and 5 acre land was granted to you.
That was subsequent.
Maybe so, but very next day, in the affidavit, I don't know if the affidavit has said that I will grant him 5 acres and it is granted the next day, it will be a valid affidavit. Because I don't have the copy of the affidavit.
Yes.
The affidavit.
There was no grant at all prior.
No, I understand, but he has also enclosed annexure R1, which indicates.
It has not been granted to me.
Show me the affidavit annexure R1. This affidavit in annexure R1, which were filed in the contempt.
It was in the contempt petition.
Where is it? Then the affidavit. Now, what is your grievance? Now you have granted 5 acres.
It only on paper, nothing apartments.
What is your prayer in the petition?
My prayer is, I'm seeking 10 acres of land in survey number 26 of Mandiri Kopa village.
No, out of 10 acres, 5 acres is granted. Let us see whether that 5 acres is handed over to you or not.
Not handed. Now, Milord, they say in Rampura 4 acres they want to grant.
Then what is the meaning of this affidavit saying that you will grant him 5 acres of land? Where is the affidavit? You produce the affidavit. You also produce annexure R1 along with the content. If you have informed the division bench that you were granting him 5 acres in survey number 26 as per annexure R1, how can you go back on this? ಕಂಟೆಂಟ್ ಬಚಾವ್ ಆಗೋದಕ್ಕೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡೋದು ಆಮೇಲೆ ಇನ್ನೊಬ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರು ಅಂತ ಅದನ್ನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡೋದಾ? How can you say there is no cancellation in the light of this affidavit that you have given, saying it has been granted? Keep the DC present. Deputy Commissioner. Leonard AG is directed to furnish a copy of the affidavit, counter affidavit, and annexure R1, which was produced. The record. Office is directed to put up the entire file relating to CCC number 1092/2019. Deputy, the fourth respondent, Deputy Commissioner, shall be personally present at the next day before list on. You'll be in trouble if there is something wrong with the affidavit. But if you were to say this now, saying that there is no order for cancellation, but he never granted the 5 acres in survey number 25, then he has filed a false affidavit. I will initiate action against him. Before he comes, let him be aware. If the affidavit indicates that he has granted 5 acres in survey number 26, and now if he is going to give this letter, one Deputy Commissioner Shimoduke, if he has said that, and now he says there's no question of cancellation, then I think he's in trouble. Next witness.
On 14.
14. என்னது?
The relation has been done within 15 years from the date of issuance of the certificate.
The order is passed by the appellate tribunal. Page number?
28.
Same.
Order question. Mr. Land was granted on 23/3/1979.
Immediate and marbutra.
After the
La form number 10 agi takshna. 3/7/2004 form number 10. 11/10/2004 sale it. 15 years from which date?
Occupancy.
Condition near the narration for 15 years from which date?
15 years from 23 to 1970.
The provision in it.
Provision section 61 amendment. The judgmental law. Where past is the- amendment from the date of order land right, not from the issuance of the farm table.
But section 61 was the prior to amendment. It was from the date of issuance of certificate under section 55 and 30.
Amendment. Later it has been amended.
So no, but when you got the order, it was 15 years from the date on which form number 10 was issued.
The amendment was carried in year 1990. I got the sale deal on 11/10/2004.
Correct, but when your vendor got this property under the orders of land tribunal, he was aware that he should not sell the property for a period of 15 years from the date of registration. That is the date of issuance of form number 10. And form number 10 is admittedly issued only in 2004.
2003/7/2004.
So if you apply that prevailing law,
Date of March.
ಮಾಡಿದಾರ?
From the date of original order of the land, to the period. Sale is of the year 2004.
ಒಪ್ಕೊಳ್ತೀರಾ? You agree? Which is the first order? The assistant commissioner with the impugned order has ordered for exemption of the land on the ground that the land granted to the vendor of the petitioner was alienated in violation of the period prescribed in section 61 subclause 1 of the Land Reforms Act. The said order has also been affirmed by the Karnataka Appellate Tribunal. The records indicate that the Land Tribunal passed an order in favor of Shubhamma on 23/3/1979. But the certificate of registration, bracket form number 10, was issued only on 3/7/2004. It is stated that the petitioners purchased the property on 11/10/2004. The authorities have taken the view that since the alienation was within the period of 15 years from the date of issuance of the certificate of registration, the same cannot be accepted. By Act number 34 of 98, section 61(1) was amended, and in place of bracket code from the date of certificate under section 55 is issued, openly bracket, from the date of the final order passed with the tribunal under subsection 4 or subsection 5 or subsection 5A or of section 48A has been substituted. By virtue of this amendment, the period prescribed for non-alienation would be 15 years from 23/3/1979. When consider the petitioner places reliance on the judgment rendered by this court in ILR 2002 Karnataka 3603 and also the unreported judgments in WP 4575 by 2020 and WP 4499 by 2020 to contend that this court has already held that the period of reckoning would be the date of the final order of the land tribunal and not the date of issuance of the certificate of registration. In the light of the decisions rendered by this court, it will have to be held that the period of alienation in the incident case would commence from 23/3/1979 and not from the date of issuance of the certificate of registration. Since the alienation is made nearly 25 years after the order of the land tribunal in the year 2004, the impugned orders cannot be sustained and the same are accordingly quashed. Petition is allowed. 47 leave aitra. Number 47 N Kumar. Nobody appeared. Next witness. Next witness. Ready. What is the proceeding about? What is the impugned order?
After standing the name of petitioner has been cancelled by the assistant commissioner and it has been confirmed by deputy commissioner.
On what ground?
On the ground that it belongs to father-in-law of fourth respondent. The father-in-law of fourth respondent sold the said property in favor of first petitioner on 24/6/1970. Annexure B is the sale deed.
Registered sale deed?
Registered sale deed. On the basis of the sale deed, the Kata has not been transferred immediately. My lord, it has been transferred on 2013. Thereafter, the first petitioner executed release date in favor of second petitioner. Annexure C1 and
what does the assistant commissioner say about the sale deed?
assistant commissioner has they are not intimated before the assistant commissioner with regard to sale deed, but they have been intimated before the deputy commissioner with regard to sale deed. But the deputy commissioner, when passing this order, does not consider the same.
Your father-in-law sold the property?
Yes.
The execution before the BC does not disclose this fact. And
is it a fact that your father-in-law sold the property to him and registered sale deed? Have you gone to the civil court for a declaration?
even the Kata was transferred.
If there's a registered sale deed in favor of the petitioner,
Yeah, it is a take property.
who is to declare that? Can you declare it by yourself?
No, that is not filed. Filed before the either.
All right, it is filed. It is filed before this court. It is filed before this court.
Yeah, it is filed before this court, but I didn't confirm the details.
Can I decide? Can I decide?
It is paid, and it is not, even if it is there, according to them. It was a family property and executed, they got the same thing executed on. That is what they.
In a writ
I
petition,
don't admit it.
in a writ petition, can I decide on the validity of the sale deed?
Yeah, yes, I agree. But the only thing, I will point out the mistakes.
Let we will assume. We will assume.
Even though they have a sale deed, it should be proved beyond doubt.
Even if they have a sale deed, it is incumbent upon you to challenge the sale deed. So long as there is no challenge to the
They
sale
have
deed,
to make declarations.
you have to fill.
No, they have to, because they have not produced it before the lower AC, either before the AC or DC. Even before the DC, the matter which was carried is something else with regard to the extent of land. It was one acre 13 hectares. Actually, it is 1 acre 23 hectares.
Will AC
I will
or
read, I will read.
49 of the order of deputy commissioner.
I will
It is-
read.
it is there, my lord.
I will read
Page
that.
49,
And-
point 3, my lord. ಪ್ರಶ್ನಿತ ಜಮೀನು ದಿನಾಂಕ 29/6/70 ಚಿಕ್ಕಪ್ಪ ಬೋರ್ನಿಂಗೇಗೌಡ 1ನೇ ನಾವಾರರಿಂದ ಕ್ರಯಕ್ಕೆ ಪಡೆದು
It has been noticed by the Deputy Commissioner. It has been noticed by the Deputy Commissioner at page 49. The sale deed.
Yeah, no, it is, but the matter which was challenged is with regard to extent of that.
Ella, you don't seem to appreciate.
And moreover, how they could manipulate the documents. R1 I have produced. R1, page number 8.
Who was your father-in-law? Borlingegowda.
Shivaswamy.
Borlingegowda had how many children?
Borlingegowda had 4 children.
And how can you claim exclusive rights over this
They
particular?
are not, they are not alive because they are not in.
Sorry,
So long-
Not be traced because
not
they-
in-
no, that is not, that is there in the order also.
So long as there is sale deed, you cannot get Kata in your name.
But they have to prove their, they have to file the.
You will have to challenge the sale deed when you don't dispute the fact that there is a sale deed. According to which a fraudulent sale deed. Therefore, you have to go to the civil court, obtain a decree.
When the fraud is, cloud is raised over the plaintiff's title and he does not have possession, he is not in possession of the property.
Inayutala case tana.
DC,
Inayutala case tana. Just Ravindran's judgment.
yeah, I have stated the statement. I have stated in the document. And they have filed declaration.
All right, I'll consider.
The plaintiff is-
That is all. Chana.
ಮತ್ತೆ ಇದರಲ್ಲಿ ಈ ಮ್ಯೂಟೇಶನ್ ಹೇಗೆ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ they have shown this one has shown he is the son of some other tribe. Let us go to the same way. Shivaswamy bin Dasegowda. Actually, in the petition,
You had purchased this property. Shivaswamy had purchased this property.
he has given this name as Shivaswamy, son of
Mavegowda.
Mahadeva. Because why that property was standing in the name.
Come at 2:30. We'll continue at 2:30. Others I'll repeat next Wednesday. Hearing, I'll take it. Nimdala, ಬೇರೆ cases. 66 and the final hearing matter, I'll take it up at 2:30. The others will repeat next Wednesday.
Your lordships,
Intermod extend ಮಾಡ್ತೀನಿ.
your lordships,
ನೋಡಿದ್ದೀರಾ 64. Then interim order ಬೇಕಂತ. Come at 2:30.
your lordship, serial number 56, interim order needs to be extended.
It will be extended.
Please.
60. Next Wednesday. 60 reach next week reach ಆಗುತ್ತೆ. ಇವತ್ತು ಯಾವ್ದೋ ಒಂದೆರಡು ಮಾಡಿ ತಗ್ಲಾಕೊಳ್ತೀವಿ ಇದ್ರೆ ರೀಚ್ ಆಗುತ್ತೆ. Number 64 and final hearing matter, I'll take it up. Others repeat next Wednesday. Interim order ಎಲ್ಲ section. No control.
Court officer. Court officer. Court officer.
officer. Court officer. Court officer.
Court mute ಆಗಿದೆ ನೋಡು.
ಹಲೋ ಸರ್, ಇದು 23 ನಲ್ಲೇ ಇದಿರಲ್ಲ, ಈ 230 ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಒಂಚೂರು ಕೇಳ್ಬಿಡಿ ಸರ್. 230 ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಲ್ವಾ? ಓಕೆ ಓಕೆ. ಪಾಸ್ವರ್ಡ್ ಎಷ್ಟೊತ್ತು ತಗೊಂಬ ಸರ್, ಗೊತ್ತಾ ಏನಾರ? ಅದೇ 2 ಇದೆ. ಹಾ ಸರಿ ಸರಿ. ಓಕೆ ಓಕೆ ಸರ್. ಹಾ ಆಯ್ತು ಸರ್, ಆಯ್ತು ಸರ್, ತಗೊಳ್ತಾ ಸರ್. ಹಾ ಸರ್, ಹಾ ಸರ್. So keep green sheet further.
In the printers.
Green sheets. Few.
Put them in the printers.
Yes. Nothing. Green sheets are there, right?
Yes.
Legal size. Then they go. So this one. Something, won't find anything, is in High Court, this is the format. Presentation form, is index, then all the copies which you have, then a batch resheet. And no stapling. Only the stitching. Stitch only and stitch. Right bottom. To know what is the clerical job, what is the job of the judge, right? I suggest you practice in judges chamber. Oh. Yes, I used to stitch like yes, especially this much at least. How do you get so much thread? We have a machine. this format can't be beaten. Can be saved. You'll get it in code, like it's very handy. Whatever. Just one page. Oh. But did you type this? No, this is from. Eight and get ready. Take.
How many petitions are there? When did it die? 18. It is reported that the first petitioner is no more and steps will be taken. New research submission released after 2 weeks. Number 1, number 53. Okay.
He had 3 sons, that is Terikuttegowda, alias Madegowda, Gurulingegowda, Boraringegowda. Boraringegowda, they acquired the suit property and the partition deed annexed the game. That is registered partition deed. In that descheduled property was acquired. That is the suit property was acquired by Boraringegowda. That is 248.
Descheduled.
Descheduled.
To Boraringegowda.
Boraringegowda. 248.
What is the date of the partition?
25/4/1962. That is the registered partition.
Okay.
They said Boraringegowda has mortgaged the suit property in favor of Dasegowda. To discharge the said mortgage deed, he has sold the suit property in favor of his brother Shivaswamy. That is Shivaswamy.
Date.
29/6/1970. The next step is the same.
29.
6/1970. 75, 29.
Borlingegoda sold it to
In favor of Shivaswamy, son of Terikuttegowda alias Madegowda.
how are you related to Shivaswamy?
Brother, Annan Maga. Borlingegoda or Annan Maga.
You are the first petitioner.
Yes, sir. Shivaswamy is the first.
We schedule property sir number ಎಷ್ಟು? That was purchased in annexure A.
There is 248 per 4 million. 1 acre 13.
248
Per 4.
1 acre.
13 quintals.
Borlingegoda sold it to Shivaswamy.
Shivaswamy. But till 2013, Tata has not been affected in the name of Shivaswamy. But in column number 12, the name of Shivaswamy was reflecting since from 1997 megawatts. Annexure C. Annexure C, case 32. In column number 12, name of Shivaswamy has been entered. Column number 9 ಅಲ್ಲಿ mortgage, Kasagowda mortgage ಮಾಡಿದ್ದಾರೆ, ಅವರ ಹೆಸರೇ ಬರ್ತಾರೆ. ಚಿಕ್ಕನ್ವೇಗೌಡ son of Kasagowda, ಅವರ ಹೆಸರೇ ಬರ್ತಾರೆ. Thereafter, in the year 2013, without Shivaswamy, the mutation entries has been changed in the name of Shivaswamy.
MR?
In the year 2013, annexure C.
MR number.
MR H12 of 2013-14.
Annexure
C1 page 35.
Annexure C is an RTC.
Yes, madam. That is annexure C1 madam. C1 page 35.
No, the annexure D, page 36. H33.
ಅದು ಆನಂದ್ ಸೆಕೆಂಡ್ ಪೆಟಿಷನರ್ ಚೇಂಜ್ ಆಗಿತ್ತು, ಶಿವಸ್ವಾಮಿ ಚೇಂಜ್ ಆಗಿತ್ತು. ಇದರಲ್ಲಿ ಕಾಲಮ್ 10 ನಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 35 MRH 12 of 13-14.
Of Shivaswamy.
Yes.
Then MRH 33.
Thereafter, Shivaswamy executed release deed in favor of his son, that is the second petitioner, releasing the settled property, that is on 18th February 2019.
Mutation in favor of P2.
P2 on 18th February 2019, annexure F.
On basis of
On the basis
Release
of
date.
release deed,
dated
18th February 2019.
the MR 33 ಬಂದ್ಬಿಟ್ಟು 19th.
ಹೌದು ಸರ್.
13 ಅಂತಾನೆ ಇದೆ ವಹಿವಾಟು ವರ್ಷ. ಪೇಜ್ 36 ಶಿವಸ್ವಾಮಿ.
ಅವ್ರ ಹೆಸರು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿತ್ತು, ಆಮೇಲೆ ರಿಲೀಸ್ ಡೇಟ್ ಮಾಡಿ.
ಇಲ್ಲ, ಸೊ 19 ಅಲ್ಲ, 9 ಕರೆಕ್ಟ್ ರಿಲೀಸ್ ಡೇಟ್ ಯಾವತ್ತು?
ರಿಲೀಸ್ ಡೇಟ್ ಡೇಟೆಡ್ 18/12/19. ಅದರ ಮುಂಚೆನೇ MR ಶಿವಸ್ವಾಮಿ ಹೆಸರು ಆಗಿದೆ.
ನಾಟ್ ಇನ್ ದಿ ಬೇಸ್ ಆಫ್ ದಿ ರಿಜಿಸ್ಟರ್ಡ್ ರಿಲೀಸ್ ಡೇಟ್.
On basis of party. Thereafter, the superseded property was released in the name of second petition. The fourth respondent hearing, claiming the daughter-in-law of Borlingegoda, filed an appeal before the assistant commissioner to cancel the mutation.
By Radha.
So Borlingegoda had 5 children.
Daughter-in-law.
Daughter-in-law has been tried. Page 46, genealogical tree, AC order with this.
That is allowed on the ground.
On the ground that now sale deed ಆಗಿರೋದನ್ನ ಹೇಳಿಲ್ಲ, ಅದಕ್ಕೆ that's been allowed. Court has, assistant commissioner has come to the conclusion that Borlingegoda has acquired the property and the partitions. Thereafter, other names should be assessed. Maybe
The partition is 25/4/62, in which Borlingegoda was granted the property.
yes.
This on the basis of the registered partition dated 25/4/62.
Yes, please. On the basis of registered partition, it is assistant.
The sale in your favor on 29/6/1970 was
Has
not.
not been brought in notice of assistant commissioner. Thereafter, the petitioners made an appeal before the deputy commissioner.
You were a part, you also did not bring it to the notice of the AC.
AC ಮುಂದೆ ಅವರು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ advocate ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. Thereafter, we made an appeal. In that appeal, we have specifically mentioned page 49. Specifically mentioned about execution of sale deed by Koraling. Neither the respondent disputed nor the assistant deputy commissioner considered that sale. Even contention is that both the got has executed sale deed in favor of.
So it's not considered the sale deed at all.
Sale deed at all. It's not whispered about the sale deed. The said sale deed has not been disputed by the fourth respondent before the deputy commissioner. But the deputy commissioner only on the basis that
Where does the respondent talk about the sale deed? Or objection in Akadra?
really ಹೇಳಿಲ್ಲ. Page 49, point number 3 is ಸ್ಪಷ್ಟೀಕರಣ ಜಮೀನು ದಿನಾಂಕ 29/6/70 ಚಿಕ್ಕಪ್ಪ ಬೋರ್ಡಿಂಗೇಗೌಡ 1ನೇ ಮಾವರವರಿಂದ ಕ್ರಯಕ್ಕೆ ಪಡೆದು ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತಾರೆ.
ಅವ್ರ objection in Akadra?
ಅವರ ಅಬ್ಜೆಕ್ಷನ್ ಏನಾಗಿದೆ ಸ್ವಾಮಿ ಓರದಿದ್ದೇವೆ ಲಿಖಿತ ತಕರಾರು ಪೇಜ್ 51 ಅದರಲ್ಲಿ ಅವರು ಅದನ್ನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ. Page 51. The deputy commissioner confirmed the order of the this been challenged on the basis of sale deed method. Data has been declared in favor of first petitioner. Thereafter, it has been transferred in the name of second petitioner. Since from 1975, petitioners are in possession and discharge.
Yes.
As per the partition, Shivaswamy has been elected with
We schedule.
They should. 244/8, 245/3, and 248/4 also.
Remember?
248/4 also.
What is the extent allotted to him?
Yes, Shivaswamy.
ಎಷ್ಟು?
Very good. Total was there. And they are confusing that 248/1, 248/3, 100 rupees.
248/1, 248/3, totally measuring 1 acre 12 guntals.
ಈ 248/4 ಮಾತ್ರ 64 acres. ಅದರಲ್ಲಿ ಒಂದೊಂದು ಪೋರ್ಷನ್ ಹಾಗಾಗಿ ಆರ್ಟಿಸಿ ನಾವು ಹೇಳ್ತಾರೆ ಆರ್ಟಿಸಿಯಲ್ಲಿ 248/248
ಸೊ ಅವ್ರಿಗೂ ಒಂದು ಭಾಗ ಕೊಟ್ಟರು, ನಿಮ್ಗೂ ಒಂದು ಭಾಗ ಕೊಟ್ಟರು.
ಅದಕ್ಕೆ ಆರ್ಟಿಸಿ ಅಂತ ಅವರ ಹೆಸರು ಕಾರಣದಿಂದ ಅವರು ಹೇಳ್ತಾರೆ. So there is no dispute. As far as partition deed is concerned, it is a registered document.
All of you are claiming under the partition deed.
And when such is a matter, 1967 ನಲ್ಲಿ ಅವರ ಪ್ರಾಪರ್ಟಿಯನ್ನು ಮುಸಲ್ಮಾನರಿಗೆ ಮಾರ್ಗೇಜ್ ಮಾಡಿ ಅವರಿಗೆ ಚಿಕ್ಕ ಹನುಮೇಗೌಡ
1967 ಬೋರ್ಲಿಂಗೇಗೌಡ mortgage to ಚಿಕ್ಕಹನುಮೇಗೌಡ. ಡೇಟ್ ಏನು mortgage?
ಅದು ಡೇಟ್ ಮತ್ತೆ ಸರಿಯಾಗಿ ನಾವು ಪಾರ್ಟಿ 1967 ನಲ್ಲಿ and
This is 248/4.
ಅದು 248/2 completion ಆಗಿದೆ.
We are concerned with 248/4, which was mortgage of Borlingegowda. Mortgage.
Chikkahnumeggowda got this property located in this name by virtue of.
Alright. When was it redeemed according to you?
Release subsequent. Separate document.
order ಇದೆ ಎಲ್ಲ ವಿಷಯ ಆ ಪ್ರಾಪರ್ಟಿ ಮುಖ್ಯವಾಗಿ ನೋಟಿಸ್ ಅವಿ
in the name of Chicken Megoda.
ಈ ಶಿವಸ್ವಾಮಿ ಅಂತ ಹೇಳಿ ಬರ್ತದೆ ಅವರ ಹೆಸರಿಗೆ ಎಕ್ಸ್ಟೆಂಟ್ ನೋಟಿಸ್
No.
80 to 84.
Complete the facts. You admitted that Borlingegoda mortgage is property Chicken Megoda. It is a usufructive mortgage. 67 mortgage andro. La mortgage is 65, 66. Inaka? 50? Then angare yavattin mortgage nodu. Mortgage redeemed by Borlingegoda.
1967 is mortgage method.
The 65 maybe another mortgage. Yavada 67 yavadu?
1967 is the mortgage.
Date.
38/1967.
Mostly earlier mortgage was.
Before execution of said mortgage has been redeemed.
So you don't know the date of redemption of the 67 mortgage.
ರಿಡೆಂಪ್ಷನ್ ಆಗಿದೆ ಅದೊಂದು ಇವರಲ್ಲಿ ವಾದದಲ್ಲಿ ಹೇಳ್ತಾರೆ
ಅಲ್ಲ ನಿಮ್ ಮಾವ ಬೋಗೆ ಇಟ್ಟಿದ್ದು ವಾಪಸ್ ತಗೊಂಡ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. So ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಹಂಗಾರೆ. If you not said that, that means the mortgage continues. Is that your case? When? No, have you produced it there? That's all. Then.
But they have produced and it was executed by the order. DC
ಏನಂತ ಇದೆ? ಯಾವಾಗ ಅಂತ ಗೊತ್ತಿಲ್ಲ. So after it was redeemed, we will accept this redeemed. Was the revenue interest built again back in the name of Borlingegoda? ವಾಪಸ್ ಅವ್ರ ಹೆಸರು ಹಾಕಿದ್ರ ಬೋರ್ಲಿಂಗೇಗೌಡರ ಹೆಸರು ಹಾಕಿದ್ರ? So the Kata continued the name of Chicken Megoda right from 1967, and your father-in-law did not dispute that, he accepted it. From 67, the name of Chicken Megoda in the revenue records was accepted by. You didn't listen to me. Your father-in-law Borlingegoda did not challenge the entry made in favor of Chicken Megoda from 67 till.
Again, continued as it is. Subsequently, what happened? Shivaswamy, the petitioner.
If Borlingegoda had not challenged the entry in favor of Chicken Megoda, how can the daughter-in-law challenge the entry in respect of this particular land?
Subsequently, petitioner got the property mutated in east.
On the basis of the sale deed dated 1970.
How he can get the property mutated in his name? But Dasegoda then Dasegoda bin Chippahammegoda.
So according to what you say, the mutation was made from Chicken Megoda in favor of his son Dasegoda. But the entry indicates that it was in.
That is in the year 2013, 10/10/2013.
Where is that print in 2013? Yes.
ಶಿವಸ್ವಾಮಿ ಸಣ್ಣಾಟ ದಾಸೇಗೌಡ ಅಂತ ಹೇಳಿ ಮುಖ್ಯಸ್ಥರು ಹೆಸರು ಅದು ಭೌತಿಕಾತ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ. ಅದು ಭೌತಿಕಾತ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ. You should have produced the list of them. When he has purchased it.
All right, we will assume that this is wrong. We will assume for a minute that it is wrong. So long as you accept the fact that the Kata is the name of Chikan Megoda and thereafter you have Dasegoda. If you have never challenged it. First question, is it your case that the mortgage was redeemed?
I will.
If your father-in-law has accepted the name of Chikan Megoda.
I will produce I have already
ನನ್ನ question answer ಕೇಳಿದ್ರೆ ನಾನು ಮುಂದಕ್ಕೆ ಹೋಗಕ್ಕೆ ಆಗಲ್ಲ. You admit that the property was mortgaged to Chikan Megoda. So therefore the question is, if your father-in-law accepted the name of Chikan Megoda from 1965 till 2013, on what basis are you challenging? Why badala nange? He has accepted the entry. Borlingegoda during his lifetime never challenged that. So the children also accepted the entry of Chikan Megoda. My question is, what is your locus standi? We will assume that this is completely illegal. Who are you to challenge it? Who are you? What is your right over this land? You don't seem to understand the difficulty that you are in. Your father-in-law, according to you, mortgaged the property. It was a usurpatory mortgage in favor of Chikan Megoda. There is nothing on record to indicate that your father-in-law got the mortgage redeemed. On what basis can you, the daughter-in-law, claim the entry to be made in your favor? Your father-in-law gave up your property. Sir, you lost the right by virtue of the fact for 30 years. You did not seek for redemption. Well considered.
ಶಿವಸ್ವಾಮಿಯ ಹೆಸರಿಗಾದ ಮ್ಯೂಟೇಷನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ. ಮೇಲ್ಮನವಿಯನ್ನು ಅಂಗೀಕರಿಸಿ ಉಪೇಕ್ಷಕರಿಗೆ ನೋಟಿಸ್ ನೀಡಿದ 15/15/15ರಿಂದ 8/8/2015 ವಿಚಾರಣೆ ನಡೆಸಲಾಗಿದೆ. ಅದರಲ್ಲಿ ಉಪೇಕ್ಷಕರು ವಕೀಲರು ಆದರು. ಮೂಲ ಪುರುಷ ಕೆಂಪ ಯೋಗೇಗೌಡರ ಮಗ ಮರಜೋಗೇಗೌಡರಿಗೆ 3 ಜನ ಮಕ್ಕಳು. ಹರಿಪುಟ್ಟೇಗೌಡ, ಎಲಿಯಾಸ್ ಮಾದೇಗೌಡ, ಗುರುಲಿಂಗಯ್ಯ, ಗುರು ಚಿಕ್ಕಣ್ಣ, ಗೋರಲಿಂಗಯ್ಯ ಒಂದನೇ ಮನವಿದಾರ ಮಾವ ಆಗಬೇಕಾಗಿರ್ತದೆ. ಅದರಂತೆ ಮಾದೇಗೌಡ, ಗುರುಲಿಂಗಯ್ಯ, ಚಿಕ್ಕಣ್ಣ, ಗೋರಲಿಂಗಯ್ಯ ಅವರು ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡಿರ್ತಾರೆ. ಮೇಲ್ಮನವಿದಾರರ ಮಾವ ಗೋರಲಿಂಗಯ್ಯ ಅವರು ಅವಿದ್ಯಾವಂತರಾಗಿದ್ದ ಕಾರಣ ಇವರ ಆಸ್ತಿಗಳನ್ನು 1ರಿಂದ 4ನೇ ಎದುರುದಾರರ ತಂದೆ ಚಿಕ್ಕಮ್ಮನಗೌಡರವರು ಅಕ್ರಮವಾಗಿ ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡಿರ್ತಾರೆ. ಹೋಗಿ ಮಾಡಿರುವ ತೀವ್ರ ಪತ್ರವನ್ನು ಶ್ರೀರಂಗಪಟ್ಟಣ ತಾಲೂಕು ಅರಕೆರೆ ಹೋಬಳಿ ಬೆಳ್ಳೆಕೆರೆ ಗ್ರಾಮಕ್ಕೆ ಸರಿಯಾದ
ಮೇಲ್ಮನೆಯವರ ಮಾವು ಬೋರ್ಲಿಂಗೆ ಅನ್ನೋ ಹಿಸ್ಸೆಗೆ ಒಂದನೇ ಎದುರುದಾರರಿಗೆ ಬಂಡೆಕೆರೆ ಗ್ರಾಮದ ಒಂದು ಸರ್ವೆ ನಂಬರ್ ಬೇರೆ
148 ರಲ್ಲಿ 1 ಎಕರೆ 12 ಗುಂಟೆ ನೋಂದಾಯಿತ ಬೇಗಪತ್ರದಂತೆ ಬಂದಿರುತ್ತದೆ. ಒಂದನೇ ಎದುರುದಾರರ ಹೆಸರಿನಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 248/3ರಲ್ಲಿ 1 ಎಕರೆ 8 ಗುಂಟೆ ಜಮೀನು RTC ಸಹ ಬಂದಿರುತ್ತದೆ. ಈ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಒಂದನೇ ಎದುರುದಾರರ ಮರೆಮಾಚಿ ಮೇಲ್ಮನವಿದಾರರು ಮಾವ ಅವಿದ್ಯಾವಂತ ಹಾಗೂ ಇಬ್ಬರು ಮಕ್ಕಳು ಸುಮಾರು ವರ್ಷಗಳಿಂದ ಕಾಣೆಯಾಗಿದ್ದನ್ನು ದುರುಪಯೋಗಿಸಿಕೊಂಡು ಮೇಲ್ಮನವಿದಾರರ ಹೆಸರಿನಲ್ಲಿರುವ ಸ್ವತ್ತನ್ನು ಅಕ್ರಮವಾಗಿ 1ರಿಂದ 4ನೇ ಎದುರುದಾರರ ತಂದೆ ಶರೀಕಾಗಿ ಮೇಲ್ಮನವಿದಾರ ಗಮನಕ್ಕೆ ಬಾರದಂತೆ 2ನೇ ಎದುರುದಾರ ಹೆಸರಿಗೆ MR ನಂಬರ್ H12/2013-14 ಮತ್ತು MR H1333 ಅಂತ ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡಿರ್ತಾರೆ. ಆದ್ದರಿಂದ ಈ ಆದೇಶಗಳನ್ನು ರದ್ದುಪಡಿಸಿ ಶ್ರೀರಂಗಪಟ್ಟಣ ಅರಕೆರೆ ಹೋಬಳಿ ಬಿಳಿಕೆರೆ ಗ್ರಾಮದ ಸುಮಾರು 248/4ರಲ್ಲಿ 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನನ್ನು ಮೇಲ್ಮನವಿದಾರ ಹೆಸರಿಗೆ ಅಂಗೀಕರಿಸುವಂತೆ ಮೇಲ್ಮನವಿ ಮತ್ತು ಇತರ ಪರ ವಕೀಲರು ವಾದ ಆಗಿರುತ್ತದೆ. Now you wanted the entries, you challenge entries in their favor and asked for your names to be entered. You admit that there were 2 children of Borlingegoda who are not to be seen. You did not choose to make them as respondents also. You claimed ನೀವು ಅವ್ರ ದಾಖಲಾತಿ I think you should file a suit.
So ಇದನ್ನು ಇಲ್ಲಿ ಕೂಡ ಶಿವಸ್ವಾಮಿಯ ಹೆಸರಿಗೆ ಮ್ಯೂಟೇಶನ್ ಎಂಟ್ರಿ ಚಾಲೆಂಜ್ ಮಾಡೋದು
ಖಾತಾ ಬೋರ್ಲಿಂಗೇಗೌಡರ ಹೆಸರು ಇದ್ದಿದ್ರೆ ಅವಾಗ ನಿಮ್ ಯಜಮಾನರು ಬದುಕಿಲ್ದಿದ್ರೆ ನಿಮ್ ಯಜಮಾನ್ರಿಗೆ ಬರ್ಬೇಕಿತ್ತು ಆಸ್ತಿ, ಆದ್ರೆ ನಮ್ಮ ಯಜಮಾನ್ರಿಲ್ಲ, ಆದ್ರಿಂದ ನನ್ನ ಹೆಸರು ಖಾತಾ ಮಾಡ್ಕೊಡಿ ಅನ್ನೋದು ಒಂದು. ನಿಮ್ ಪ್ರಕಾರ ನಿಮ್ ಗಂಡ ಯಾವಾಗ ಸತ್ತ ನೀವ್ ಹೇಳಲ್ಲ, ನಿಮ್ಗೆ ಯಾವಾಗ ಬಂತು ಹಕ್ಕು ಹೇಳಲ್ಲ. ನಿಮ್ ಮಾವನ ಹೆಸರಲ್ಲಿ 65ನೇ ಇಸ್ವಿಯಿಂದ 2013ನೇ ಇಸ್ವಿವರೆಗೂ ಒಂದು ದಿನ ಖಾತಾ ಇಲ್ಲ. ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿ I'll consider.
Measurement extension of the challenge, not about this. They have not accepted their right by submitting this document. They have only challenged. This was over there. That is challenge what is important. Arguments is good. Arguments ಮಾಡಲ್ಲ. ಆಗ ಏನು ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿ ನಾನೇ ಅವರ ಮಗ ಅಂತ ಹೇಳಿ ಅದು ವಿಷಯ ಅದನ್ನು ಪ್ರೊಡಕ್ಟ್ ಮಾಡಿದರೆ ಅವಧಿ ಕಾಲ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನು ಈ ಸೇವೆ ಕೂಡ ರಿಲೀಸ್ ಹೇಗೆ ಅಂತಂದ್ರೆ ಹೇಳಿದ ಈ ಮ್ಯೂಟೇಶನ್ ಹೇಳಿದೆ. They have not disclosed about this survey, even in the year 2019. What is the impact? That document in not even 1 gram. Family property only border area our ಮಾತ್ರ ಅಸೈನ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ and according to the document produced. Extent ಅದರಲ್ಲಿ ಹೇಗೆ ಅಂತ ಅದು partition bill ಅಲ್ಲಿ extent to 1 acre 23.
ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಯಾವಾಗ ACM ಮುಂದೆ ಇದು ಮಾಡಿಲ್ಲ. TC ಅಲ್ಲಿ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಫಾರ್ ದೇರ್ ಎಜುಕೇಶನ್ ಇಸ್ ಡಿಫರೆಂಟ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಮಾರ್ಕ್. ಮತ್ತೆ ಅವರದ್ದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅವರ ನೊಟೇಶನ್ ಚಾರ್ಜ್ ಮಾಡಿರೋದು and in the release date there is no reference to this statement. Notation master written. Their own document ಅದನ್ನು ಕೂಡ ಹೇಳಿದೆ. And the mutation ಮಾಡಿ ಅವರ ಯಾಕೋ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅವರದ್ದೇ ಮಗ ನಾನು ಅಂತೇಳಿ ಗೋಲ್ಡ್ ವ್ಯಾಲ್ಯೂ 1970 document 2019 ವರೆಗೆ ದೇವರ disclosing that document for more than 1 week. Can it be read out? So in the that document is or presumption that presumption will not be available because of this non-disclosure real facts. ಇವರು ಅದಲ್ಲದೆ ಇವರ ಊರಿಂದ ಓಡಿಸಿ ಒಬ್ಬರು ಮಾತಾಡ್ತಾರೆ ಅದರ ಮೇಲೆ ಗೌರವಿಗೆ ಅದರ ಮೇಲೆ 5-6 but not relevant. I can only submit. And she is in possession and in of the property. Even today, possession was not disturbed, but they tried to take possession of the property by illegal methods. ಎಲ್ಲ
ಏನದು that is not relevant here. All right.
What was the circumstance? ಅದರಲ್ಲಿ ಮಾತ್ರ ಬೇರೆ ಯಾರೆಲ್ಲ ಶೀಟ್
That's all. On what basis did you get the Khata change in your name?
Immediately, my lord, on the basis of the same day. But
Show me from that annexure, that MRH12 or 33.
I agree, but on the basis of the same day.
Where is it, sir?
It is
Let him argue.
admittedly, my lord, it has been changed. If it is suppose non-fraud mode, if the first petitioner has entered this thing by way of fraud, who is the person who is to challenge them? It is the son of Chikan Megoda. They have not challenged the claim. But
If your Khata was based on the sale deed, I will accept whatever you say. The Khata was not made in your favor on the basis of the sale deed. Isn't it?
oversight, it has to mention like that, on the basis of sale deed.
What oversight? Where's your application when you gave for change of Khata in your favor?
But in the year 2030.
$248 ಇಲ್ವಾ ಅದರಲ್ಲಿ?
Resurvey ಆಗಿದೆ.
ಅದನ್ನು resurvey
Resurvey ಆಗಿದೆ.
ಈ ನಂಬರ್
248/2, 248/4 ಆಗಿದೆ. ಕೋಡಿ ಆಗಿದೆ.
But the problem is they have not challenged the sale deed, and in the objections they say that, say, look at paragraph 9. This is what is against the respondent. Look at this look at paragraph 9 of his objections. The fourth respondent here in disputes execution of the said sale deed dated 29/6/17 in favor of Swami Gowda. The extent mentioned in the sale deed dated so and so is not in consonance with the extent allotted to Borlingegowda. They don't deny the execution. They say they disputed. If they disputed, they have to go to the civil court. They don't say that. Let us see the C para 9. C para 9 in his objections. He does not dispute it relates to the objections. ಅವರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ತಿಲ್ಲ. ನಿಮ್ದು ಬೇಸಿಕ್ ಫಂಡಮೆಂಟಲ್ ಫ್ಲಾ ಇದೆ. You claimed Kata change of Kata on the basis of the fact that you are the son of Shivaswami. You are not the son of Shivaswami. If you can show something to indicate that it was on the basis of the sale deed that you sought the change of Kata, I can understand. Even you accepted the mortgage in favor of Chikkanamegowda from 1965. Notwithstanding that, you allowed this to continue in the name of Chikkanamegowda. Both of you allowed this to continue in the name of Chikkanamegowda. Then how do I get over that?
Chikkanamegowda should challenge my body. Respondent 4 is coming and challenging that again. It should be challenged by Chikkanamegowda son of Prasegowda. Register P.
248/4. All right, go to civil court. It is a case of the petitioners that Borlingegowda sold survey number 248/4, measuring 1 acre 13 guntas, in favor of the first petitioner Shivaswami. It's the case of the petitioners that was allotted survey number 284/4, measuring 1 acre 13 guntas under registered partition deed. And the said Borlingegowda was the brother of the first petitioner Shivaswami. It is their further case that Borlingegowda had mortgaged the said property, and in order to redeem the mortgage, he sold the property to the first petitioner under registered sale deed dated 29/6/1970. Next one. It is their case that in the year 2013, the mutation was effected in favor of the first petitioner on the basis of the sale deed dated 29/6/1970. And thereafter, since the first petitioner Shivaswami released the property in favor of his son, the second petitioner, the revenue entries were once again mutated in favor of the second petitioner. Right, MRH 33/1314. Next. It is the case of the petitioners that the respondent, the fourth respondent herein, without having any basis, filed an appeal contending that she was the daughter-in-law of Borlingegowda and her name ought to have been entered in the revenue records. Next. The Assistant Commissioner accepted the appeal of the fourth respondent and mutated the name of the fourth respondent on the ground that land bearing survey number 248/4 was allotted to the father-in-law of the fourth respondent, Borlingegowda, and as a result of his death, the fourth respondent had succeeded to the said property. Next one. The petitioners preferred a revision under section 136 of clause 3 of the Land Revenue Act In the revision, they contended that the property bearing survey number 248/4, measuring 1 acre 13 guntas, had been sold in favor of the first petitioner, and therefore the mutation was rightly changed in the name of the first petitioner. The Deputy Commissioner, by the impugned order, has however proceeded to dismiss the revision. So it is contended by the petitioner that the specific plea taken by the petitioners that they had purchased the property under the sale deed dated 29/6/1970 has been completely ignored, and this has vitiated the order. Learned counsel for the fourth respondent contends that the mutation was made in favor of the first petitioner, not on the basis of the sale deed dated 29/6/1970, but on the basis that he was the son of Dasegoda. And since the entire basis for mutation in favor of the petitioner was incorrect, the Assistant Commissioner was justified in allowing the appeal. From the facts narrated above, it is clear that the suit property was in fact allotted to Borlinge Gowda under registered partition deed dated 25/4/1962. Learned counsel for the fourth respondent admits that Borlinge Gowda had mortgaged the said property in favor of one Chick Anumaya Gowda under registered usufructory mortgage deed dated 38/1967. Learned counsel is, however, unable to state on which date and under which document the said mortgage was redeemed. He also admits that the name of Chick Anumaya Gowda continued in the revenue records on the basis of the registered mortgage deed. These facts thus establish that the property was belonging to Borlinge Gowda, and Borlinge Gowda had mortgaged it to Chick Anumaya Gowda. Next part. The first petitioner sets up the case that land bearing survey number 248/4, which had been allotted to Borlinge Gowda, his brother, was in fact sold to the first petitioner under registered sale deed dated 29/6/1970. So it may be pertinent to state here that the Kata does not appear to have been changed in favor of the first petitioner on the basis of the sale deed. However, the fact remains that there is a registered sale deed in favor of the first petitioner executed by Borlinge Gowda on 29/6/1970. This assertion that there was a sale deed was also put forth before the Deputy Commissioner, who has, however, ignored the assertion. A statement of objections is filed by the fourth respondent in this writ petition, in which it is stated as follows. A reading of the said objections indicates that the fourth respondent is disputing the execution of the sale deed. It is not the case of the fourth respondent that the sale deed does not pertain to survey number 248/4, or that no such sale deed was executed. In my view, since there is a registered sale deed executed by Borlinge Gowda, the father-in-law of the fourth respondent, the only remedy available to the petitioner would be to challenge the said sale deed. So long as there is a sale deed in favor of the first petitioner, the fourth respondent cannot object to the entry of the first petitioner in the revenue records. It is also to be noticed here that the father-in-law of the petitioner, of the fourth respondent, that is Borlinge Gowda, did not challenge the entry in favor of Chick Anumaya Gowda, and his name was never entered in the revenue records from 1967. In that view of the matter, the appeal filed by the fourth respondent laying a claim over survey number 248/4 on the ground of succession from Borlingegoda would not arise. It would also be pertinent to state here that apart from the fourth respondent, it is also admitted that Borlingegoda had 2 more sons. The fourth respondent could not obviously therefore seek for mutation in her name exclusively on the ground that she had succeeded to the property on the basis of succession from Borlingegoda, and therefore of the view that the order of the Deputy Commissioner cannot be sustained and the same is set aside. The order of the Assistant Commissioner shall stand restored and the revenue entries shall reflect the name of the first petitioner on the basis of the sale dated 29/6/1970, and thereafter the revenue entries are to be changed in favor of the second petitioner, his son, on the basis of the release deed dated 18/12/1989, which is also a registered document. Next paragraph. It is open for the fourth respondent to approach the civil court and obtain an appropriate declaratory decree in respect of survey number 248/4. And if the fourth respondent were to obtain an appropriate declaratory decree declaring her rights, the revenue entries would abide by such a decree. Writ petitions accordingly allowed.
Assistant Commissioner order should also be set.
Why?
Assistant Commissioner has confirmed, allowed the petition filed by the fourth respondent.
Order of the Deputy Commissioner and the Assistant Commissioner. And the order of the Tahsildar shall stand restored. Where is the order of the AC?
Page 47, next step, G. 47. Yes, allowed the petition filed by the fourth. That has been confirmed by the
Order of the Assistant Commissioner and the Deputy Commissioner set aside, and the revenue entries shall reflect the name of the first petitioner on the basis of the sale dated 29/6/1970, and thereafter in the name of the second petitioner on the basis of the registered release deed dated 18/12/1999. What happened on 15th of March?
After that, I have been inspected. There were 4 days of hearing before the Deputy Commissioner, and the Deputy Commissioner has not considered the appeal nor the application filed by the petitioner seeking the stay of the implementation of it.
What is the order challenged with the Deputy Commissioner?
Except 3.
The date of the state in the left should be given up for 1 and 2 of the agreement by the made an application for regular action. Petition number 2 is already compliant. Because of the date of
No, but there is an order of grant rightly or wrongly. In an appeal, in a statutory appeal, if you don't grant a stay, what remains? No. Against which an appeal is preferred. In the appeal, if there is no stay granted, then what is the effect of the appeal? It becomes infructuous. I'll grant him an interim order and direct the Deputy Commissioner to dispose the appeal within a month or two. An order cancelling the grant in favor of the petitioners on the ground that they were ineligible for grant was challenged before the Deputy Commissioner. The Deputy Commissioner was challenged with the Deputy Commissioner filing an appeal on 13/12/2021. It is the complaint of the petitioners that the Deputy Commissioner has not taken up the appeal for consideration and is not considering the application for stay. Hakidara? Not considered the application for stay of the order of cancellation. So,
The application on that, petition to the application. Subsequently,
13/12 the date is application. ಅಲ್ಲ ಇವ್ರು ನನಗೆ ಕೊಟ್ಟಿರೋದು 13/12 ಅಂತ
Subsequently filed.
A copy of which is produced along with the memo dated 13/4/2022. In the light of the fact that an order cancelling the grant was challenged before the Deputy Commissioner by way of an appeal, the Deputy Commissioner ought to have considered the application for stay. If in a statutory appeal, an interim order of an order which is executable is not granted, the probability of the appeal being rendered infructuous would be strong. And therefore of the view that would be appropriate in the present case to direct the Deputy Commissioner to decide the appeal as expeditiously as possible, at any rate within a period of 6 months from the date of receipt of a copy of this order. And until then, there shall be an interim stay of the order of the Assistant Commissioner dated 3/12/2021, passed in LND RUO bracket A 71/2021, 2020-2021. With petition accordingly disposed of.
Made another proposal, delay, so I made another proposal, stating that I am willing to vacate the premises by the end of this month. Let them even at least 25% of my investment, 59. If that much let them refund, I'll vacate by the end.
Again, refund kodala. There's no point.
Whatever
You want me to pass it over? What do you want?
They mentioned for a date today.
So pass over madla, ಇನ್ನೊಂದು ದಿನ ಹಾಕೊಳ್ಳ. When do you want it? Friday. Intromotions.
Master or magistrate number 39. Number 39.
ಮಾಡ್ತಾರಾ ಇಲ್ವಾ? ಅವ್ರು ಬೆಳಗ್ಗೆಯಿಂದ ಕಾಯ್ತಾ ಇದಾರೆ, ನೀವು ಹೇಳಿದ್ರು ಬೇಡ. ಮ್ಯಾಟ್ರೋಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತಾ ಇದು? ಟೈಮ್ ಬೇಕಂತ. Next witness. Tenant's petition. Next year, scene T. $186.
discussion price usually for the grade 198 and 199.
Second paragraph, Pune Mandale Sadasya. Please read, please read. Yes.
Who ನ್ಯಾಯಮಂಡಳಿ ಸದಸ್ಯರು ತಿಳಿಸಿರುವ ಲಿಖಿತ ಅಭಿಪ್ರಾಯ ದಿನಗಳು ಮೂಲಭೂತವಾಗಿ ದಾನೆಯ ಸತ್ಯವಾಗಿದ್ದು ಅವರ ಮರಣ ನಂತರ ಭಕ್ತಿ ಸಂಸ್ಥೆಯ ಪ್ರಕಾರ ಅವರ ಸಿದ್ಧರಿಗೆ 6,957 ಪ್ರಕಾರ ಖಾತೆ ಬದಲಾವಣೆಯಾಗಿತ್ತು. ನಂತರ ಖಾತೆದಾರರ ಸಿದ್ಧ ಮತ್ತು ಅವರ ಅನಂತ ಸಂಬಂಧಿಕರಾದ ದಾನಯ್ಯ ಪಾಲಯ ಬಂದು SR 48 ದಿನಾಂಕ 14/75 ಸದರಿ ಜಮೀನುಗಳನ್ನು ಪಾಲಾಕ್ಷಪ್ಪ ಗುರುತಿತ ಪ್ರಕಾರದಲ್ಲಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅವರ ಈ ಪಾಲಾಕ್ಷಪ್ಪನವರು ಭೂ ಮಾಲೀಕರು ಮತ್ತು ಸ್ವಾಧೀನ ಅನುಭವ ಹೊಂದಿರುತ್ತಾರೆ ಎಂದು ಅರ್ಜಿದಾರ ಕುಬೇರನ್ನು ತೋಳುಕೆರೆ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ ಎಂದು ಸದರಿ ಕುಬೇರಯ್ಯನವರು ಕೇಳಿದಾರ ಅಲ್ಲವೆಂದು ತೀರ್ಮಾನಿಸಿ ಅವರ ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡಿ ಈಗ ತೆಗೆದುಕೊಂಡ ಹಣವನ್ನು ಪಾಲಾಕ್ಷಪ್ಪನವರಿಗೆ ಸಲ್ಲಿಸಬೇಕೆಂದು ಹಾಗೂ ಪಾಲಾಕ್ಷ ಸಂಸ್ಥೆಗೆ ಸದರಿ ಜಮೀನು ಖಾತೆ ಮತ್ತು ಬನ್ನಿಗಳ ವರ್ಗಾವಣೆ ಮಾಡಿಸಿಕೊಡಬೇಕೆಂದು ಹಾಗೂ ಸ್ವಾಧೀನ ಅನುಭವ ನೀಡಬೇಕೆಂದು ಮತ್ತು ಇದರೊಂದಿಗೆ ಪೊಲೀಸ್ ರಕ್ಷಣೆ ಒದಗಿಸಿಕೊಡಬೇಕೆಂದು ಅಭಿಪ್ರಾಯ ವ್ಯಕ್ತಪಡಿಸಿರುತ್ತಾರೆ. ಕರ್ನಾಟಕ ಪ್ರಕಾರ ಆದೇಶದ ನಿರ್ದೇಶ ಪ್ರಕಾರ ಸದರಿ ಪ್ರಕರಣ ಸಂಬಂಧಿಸಿದಂತೆ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಎಲ್ಲ ದಾಖಲೆಗಳನ್ನು ಸುರಕ್ಷಿತ ಪ್ರಶ್ನೆ ಮಾಡಲಾಗಿ ವಿವಾದಿತ ಜಮೀನು ಏನು ಜಮೀನುಗಳಾಗಿರುವ ಬಗ್ಗೆ ಭೂ ದಾಖಲೆ ಯಾವುದೇ ವಿವರಗಳು ದಾಖಲಾಗಿರುವುದಿಲ್ಲ. ಸದರಿ ಜಮೀನು ಪಹಣಿ ಪತ್ತೆ ಕಾಲಂ 9/12 ಭೂ ಮಾಲೀಕರಿದ್ದು ಕಾಲಂ 12/3/1900 ಸ್ವಂತ ನಮೂದವಾಗಿರುತ್ತದೆ ಹಾಗೂ ಸದರಿ ಜಮೀನು ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ 44 ಪ್ರಕಾರ ಸರ್ಕಾರದ ನಿಯಮಿತವಾಗಿರುವುದಿಲ್ಲ. ಅರ್ಜಿದಾರರು 174 ಪೂರ್ವದಲ್ಲಿ ಮತ್ತು ನಂತರ ಪಹಣಿಯ ಕಾಲಂ 12 ನಮೂದಾಗಿದ್ದರು. ಅರ್ಜಿದಾರರು ಭೂ ಮಾಲೀಕ ಏನೇ ನೀಡುವ ಬಗ್ಗೆ ನೀಡಿದ ಪ್ರಸವವಾಗಿ ಏಣಿ ಕಾಲ ನೀಡುವ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರು ಮತ್ತು ಭೂ ಮಾಲೀಕ ಮಧ್ಯ ಏಣಿ ಭೂ ಮಾಲೀಕ ಸಂಬಂಧದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲಾತಿಗಳು ಹಾಜರುಪಡಿಸುವುದಿಲ್ಲ. ವಿವಾದಿತ ಜಮೀನು ಖಾತೆ ಪಾಣಿ ನಂಜೆ ಇವರಿಗೆ 60, 70, 73, 74 ಇತ್ತು 40,000 ದಾಖಲಾಗುತ್ತದೆ. ನಂತರ 74 ಸಾಲಿಗೆ ಸದರಿ ನಂಜಯ್ಯ ಒಬ್ಬಿ ಮಗ ಶ್ರೀ ಎಂ ಸಿದ್ದೇಶ್ವರ ಹೆಸರಿಗೆ ಖಾತೆ ಪಡೆದಿರುತ್ತದೆ. 5/70 ಭೂಮಿದಾರರು ಜಮೀನನ್ನು ವಹಿಸುವ ಸಾವು ನಡೆಸುತ್ತಿದ್ದಲ್ಲಿ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ 44 ಸದರಿ ಜಮೀನು ಏನೇ ಜಮೀನು ಅಲ್ಲವೆಂದು ಶಾಸನದಲ್ಲಿ ದೂರು ಹಾಕಿರುತ್ತದೆ. ಈ ಅಂಶವನ್ನು ದಾಖಲಾತಿಯನ್ನು ಭೂಮಿ ಪರಿಗಣಿಸಿ ಅಧಿಕಾರಿಗಳು ಮಾಡಿದಂತೆ ಅಂತಹ ಅಂಶವು ಆದೇಶ ಅಸಲು ಆಗುತ್ತದೆಂದು ಆದೇಶ ಮಾಡಿದ ಪ್ರಯುಕ್ತ ಈ ಎಲ್ಲ ಆಧಾರದೊಂದಿಗೆ ಅಧಿಕಾರಿಗೆ ಅಲ್ಲವನ್ನು ತಂದು ಸರ್ವಾನುಮತದಿಂದ ನಿರ್ಣಯಿಸಿ ಅರ್ಜಿದಾರ ಉದಾಹರಿಸಿ ಸರ್ವಾನುಮತ ಆದೇಶಿಸಿ. And on page 183, tab 3.
Yes.
183 paragraph on the pure location. This is the sixth round of education, second term. Unfortunately, on the sixth round also the landowner has not considered all the evidence coming to the conclusion. The landowner being in positive study should have considered all the evidence from the spot before coming to the conclusion. So he has mentally triggered upon the entry in the revenue court and has concluded that it should not have control the property. The entry in the revenue court in the name of the tenant from 5963. Thereafter, the federal column left hand between 670. After 70, the name of the land owner appears in the federal column. In this view of the matter, the has concluded that the petitioner is not a tenant for the process question.
The spot merger is not considered by the.
By doing so, the tribunal has ignored the spot merger, which primarily discloses the position of the petitioner. The merger by NHC was made to inquiry relating to the
Let me ask the other side. This was the order. This was the order at page 183. The direction was to consider the spot merger, which indicated that the tenant was in possession as on 1974. This court actually deprecated the fact that only the revenue entries were considered.
Spot market what has been is rather not in the presence of the petitioner and not the SY landowner not sold away the property.
Where is it considered by the tribunal? No, the reasoning, the tribunal should say that the spot merger is good or bad, whether it can be believed or not believed. Merely narrating that there is a spot merger is of no consequence.
This is not because these spot market, it is not the first round of litigation. These litigations not have been preceded by various appeals and rate petitions from the previous round also. But this was the subject matter where not rate appeal also. These arguments were raised. But
If this order is correct, paragraph 4, you were actually, no, apart from that, you were precluded from giving any additional evidence. And the matter was to be heard only on the basis of the available evidence as on that date. And where is the consideration of by the land tribunal on this specific issue regarding spot merger?
While inquiry was just making that not next paragraph. It is saying the division bench of this court by deciding the matter at the earliest point of time in the of the final suit has directed land tribunal to re the parties. However, it was made clear that none of the parties should be permitted to add anything on the record, means that both the parties were restrained from using additional evidence. But after remand, the land tribunal permitted both the sides free evidence, and the tribunal has considered the additional evidence also. Hence, the procedure adopted by the tribunal is contrary. This not was what happened was first till 1992 certain evidence was laid, and not previously in the later proceedings not it was directed that there should be no further evidence. However, sixth count of remand, which was assigned to this requisition, additional evidence was reduced, which not the court said you shall not take into account. You should not take that account which has been published subsequent to the rate appeal order of the year 1999. So whatever the evidence is there on record in 1999, that is what has to be looked into. And not that is all what has been looked into in this order which is being assigned with others. Now kindly see for one moment, not for one moment. Not the other side say.
So there is no finding by the tribunal regarding the spot merger.
But they have narrated. They have narrated.
I'm asking no finding.
This that in process.
Then
Finding first, if the watch ask me, either okay, if you must you watch, maybe right, Karnataka should like the last number outdoors but not if
you are not answering the question directly, you are just beating around the bush. Has it?
I can't.
Then I'll set aside this order, let them consider the spot merger as directed by this court earlier.
I would just point.
ಯಾವ ಊರು ಇದು? ಶಿವಮೊಗ್ಗ. Or else if you want, I'll consider the merger here by consent and pass an order, whatever comes to my mind. We'll close the matter here if you're ready. If I find that the merger indicates that he is in possession as of 1374 and that is accepted by your vendor, I'll accept it and close it. Now, if you don't want an order of remand,
I just pursue your logic, not to do so. Can you see not? The facts of the matter is but the application which is filed by the petition of NAS is either dated 10 to 1975 or 1990. Because not there's a overriding here. But from 14 to 1975, this land was sold not by the erstwhile vendor in our.
if the land is tenanted, you get no title.
Absolutely. That was also discussed in the previous written record. May just take your lordship to that part also because
No, I accept. I accept.
that has been a subject matter of NAS and that has been adjudicated in the previous proceeding. And the court not said you are entitled to protect your interests.
because
If the land is not tenanted.
it is not 130. 130, so finding it by division bench not, because there was another judgment which the other side want to portray that if there is a application of whether it is a tenant, then it does not achieve the right title or because it will best clean investing in the section 44. But for that, there is an answer in the Indian case. That whether there is such clean investing or not is not a concluded fact in this matter. And if it were to be reinvesting, then probably this man doesn't get it. If it is not so, he's entitled to protect his interest. And it is observed not that the vendor has colluded. The vendor not after selling the property has colluded with the other side. That is what is also being recorded in the previous proceeding. And thereafter not it was remitted back to the land tribunal to hear the matter. No. In the previous, that is the previous bench finding. That's the previous bench. If my lordship just take over after I just narrated not, either 10 to 75 or 19 to 75 is the application, what the other side relies upon. Then my lordship will kindly see. This is election A, my lordship.
Is that argument advanced to the tribunal and a finding is given regarding this form number 7, date of the form number 7?
Form number 7.
This argument that you are now advancing about discrepancy in the dates, was it urged by the land tribunal?
That has been advanced by the, it has been. There is no finding. But what I would say is, the division bench said, it would be either of these two. But his tenancy application is not hard because 79 has a idea.
What is the point that you are trying to make?
But the point what I am trying to make before the lordship, NDC put one moment election. This is
Next, sir.
election.
A.
This is the basis on which we are trying to make out.
So I'll consider the matter on merits and close it here on.
Not yes, sir, but one thing not this one not happy over to and
Let us see.
you taken by the also. But I am resisting a demand only on this grounds not that 70.
So that's why I'll say by consent I'll take it up and close it here. I'll decide the matter on merits one way or the other. If I feel it's a case for confirming occupants' rights, there is a tribunal to grant occupants' rights. If I feel it's not a case, I'll close the matter. That is the only issue, isn't it? Spot merger. The spot. This is the finding of this court, Mr. Rao.
That is what was urgent before. That is what was urgent before. The legal finding on which it should remain NBC was the fourth para which I read out there.
It's your choice. If you want, I'm ready to decide this right here. Because my understanding of this order at page 184 is clear.
Lordships are asking whether this matter has been pursued in the order and how it is back.
You send it back or you want me to decide it here? It's up to you.
Lordship, send it back. One thing.
Anyway. An order.
No, this I think not.
Wait, let him finish.
All misplaced symbolic knots has led this litigation so far.
That's why I'm offering you. I'll decide it right here. You don't want me to decide. Benny.
The order of the land tribunal is there. The RTC will be kept under suspension.
Was your name entered pursuant to the order of the land tribunal? What will happen if this order goes? What will happen if this order goes? The record, the RTC will stand as it stood prior to the order of the land tribunal.
These are there are two things. One, there are only two. Lordship will grant your lordship will grant the land 15 days. We argue the man. Let's let it pass. I am also saying.
We waited for 11 years to send it back.
But every time. Your lordship will grant the order.
Benny.
Order sheet now.
The land tribunal. the land tribunal by the impugned order has rejected the application filed by the tenant for conferment of occupancy rights. The land tribunal has opined that the revenue records does not reflect the name of the tenant as on the relevant date, and therefore the tenant was not eligible for conferment of occupancy rights. On an earlier occasion, when the order of the land tribunal was challenged before this court in WP 2989/2004, this court stated as follows: para 3, page 183, para 4, para 5, up to 183. As could be seen from the said order, this court had categorically observed that the tribunal had ignored the spot merger, which prima facie disclosed the possession of the petitioner tenant, and the merger had been drawn up during the inquiry relating to the revenue entries, and the merger was of the year 74 and had been signed by the landlord, respondent number 1, therein by Great Siddhaya, respondent number 1 therein, and also by the petitioner tenant apart from the villagers. Despite this specific order of this court, the land tribunal in the impugned order has not recorded any finding regarding this spot margin, which had been produced as Annexure C to WP 2989/2004. In my view, in the light of the said order passed by this court, it was not open for the land tribunal to ignore the merger of the year 74. Next part. It may be pertinent to state here that this court had also observed that it was necessary for the tribunal to consider only that evidence which was available as on that date and could not rely upon any additional evidence. Despite the observation of this court, the land tribunal has once again merely referred to revenue entries and has rejected the claim of the tenant, and it has completely ignored the merger, upon which a finding was recorded by this court and a direction was also issued to the tribunal. In that view of the matter, the order of the land tribunal cannot be sustained and the same is set aside. The matter shall stand remitted to the land tribunal once again with a specific direction that the tribunal shall consider the effect of the merger which was produced as Annexure C in WP 2989/2004 and which is of the year 1974, and thereafter pass appropriate orders. Next part. As already ordered in the aforementioned writ petition, the tribunal should not look into the evidence adduced by both the parties after 3rd of October 2002, and it shall confine itself to examination of the evidence prior to 3rd of October 2002. Next part. Learned counsel for the petitioner, Shri Ashok Kalyan Shetty, contends that pursuant to the order of the land tribunal, the name of the tenant has been deleted and the name of the first respondent, name of the respondent number 3 has been entered in the revenue records. Respondent number 2. Since the entry in the revenue record is made only on the basis of the order of the land tribunal, it would be necessary as a consequence to direct that the revenue entries as it stood prior to 11/11/2011, that is the date of the order of land tribunal, be restored. WP accordingly allowed. The land tribunal shall dispose of the application within a period of 10 days agala record within a period of 3 months from the date of the receipt of a copy of this order.
There are around 7,144 positions. 7,144 positions.
You want me to appoint receiver? Receiver was appointed.
Deposit here because at some point of time application order sheet is there. I have deposited 31,000 rupees. I had closed this thing. I have deposited 31,000 rupees. We kindly ask in this to make launches taken great. 79 to 80.
No, I only want to pass an order that amount. I only want to pass an order on that amount. What should happen to that amount?
I have deposited that deposit. I'm not saying I'm not bothered with that amount. That was 79 to 80 crore loss. With an interim order loss, the terrain loss was asked to be.
ಯಾವತ್ತು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್? $62,400. The order of this court says there is no dispute that the petitioner was appointed as a receiver in the earlier proceeding and he continues to be in possession of the property from 86.
86 till 1999 not in possession. For that period, not for that period, because after that not there is no continuation. For that period, but we sought for accounts, and that sum was deposited before your lordship. I have deposited. And after that, till 99 lots, till 99, he continued so as a receiver. And thereafter, it was discontinued. And thereafter, applications were dismissed constituted. And they were in the third round after that, subsequent to 99.
No, the finding of this court is that he has been in possession right from the year 1986.
86 and 99.
99, when, how did you get into possession?
Proceedings not only got terminated in the rate appeal. The previous round not in the rate appeal proceeding. The receivership was not continued. No, yes.
So you automatically can take over the
No, we
receivership?
have not taken over.
Then?
The point is not, I stated in my statement of operations also, that not for a brief while in the tribunal, but she has been appointed as a receiver.
If he has been appointed as a receiver,
Yes, ma'am.
until it is discharged and possession is ordered to be handed over to you, you can never get into possession.
I am not saying I am in possession of the property. I have stated that clearly in the statement of objection because of the dispute. Nobody is there in possession of the property post 1999. There is an attempt by all the parties. I am not saying him alone. There is an attempt by both of them not to take possession of the land. Tashildar not intervene, taking note of the situation. Not 144 proceedings CRPs was initiated. Not and he had taken over the possession of the property for on many other occasions. That is why I said not. There were law and order problems in current litigation subsequent to 1999 not. On 8 occasions, not proceedings under 144 was initiated by Tashildar.
Then I will appoint him as a receiver once again.
I don't think so that because he was not continued post 1999. But the position of the land remained with Tashildar on various occasions. And none of us have filed applications not seeking the.
This order was passed in 2014.
But this order not passed in 2014, we having regard to previous. But between
No,
1986.
this court records a finding.
I can point it out.
This court records a finding that he has been in possession and he has realized certain monies from the. Therefore, this court has accepted the fact that he is in possession. No, your application was to direct the petitioner to deposit a sum of rupees 1,27,500, being the value of the crop harvested. So you also admit that he was in possession.
As a receiver between 1986 to 1999.
This application was filed in the year 2012. So I will only continue that order. Why do you want to get into some trouble there again? You will again fight, again Tahsildar will come.
If that was the case, I can point it out to you, but the order of the receiver came subsequent to 1999, has not been there. If you watch it, I can point it out.
So what is the effect according to you?
First, Tahsildar not had assumed possession of his lands and 145 proceedings.
From whom did he take possession?
From both of us, when there was a
When you admit that you are not in possession, now where is the question from both of you?
the possession, kindly see, not in 1986 for the first time, not by interim order of lots, he requested, not an tenancy application by him was allowed. And not for an interim order by when the same was challenged not, and not it was allowed. There was a request made, let me be appointed as a receiver. Kindly see how the proceedings went on there. Not he went into the property saying that, but let me be appointed as a receiver in the year 1983. Thereafter, not in 1986, first was appointed as a receiver.
And did you challenge that order?
No. By 1999, can you see 1999?
Today, action I'll continue my
I will object.
I'll consider your objection. I will consider your objection seriously.
Wrong in the previous proceedings, it has led to this dispute.
All right.
That's why I'm making the submission before the lawyer. Grant this 1 or 2 months time with finish the proceeding. I'm ready to take the law on merits. And your lordship is relying on that margin. And your lordship is relying on that margin. Your lordship will kindly see. It is not anti-legal. It is not pendant right. Before the proceedings of the land tribunal, your lordship recorded that when the proceedings of the pendency of the proceedings before the land tribunal are made, the land tribunal did not reject them. Land tribunal proceedings started somewhere in the year 1977. This margin lots were drawn up by the revenue inspector, not so.
I have not said drawn up by the land tribunal. I said the spot margin produces annexure C. I have specifically said spot margin which is produced as annexure C. Which is produced as annexure C. Whatever is the spot margin, it is spot margin.
That was one fact. No, that is recognition. I'm putting it in this. Recognition. These revenue is not subsequent to at least 1994. It's not followed right. And there is a notification
that order is over now. There's no point in re-arguing. I'm only on the question of possession because the order dated 27/6/2012 states, for the present, the report of the revenue inspector Basavapatna depicts that it is Sri M. Kuberaya, son of Siddhaya, who has cultivated the land in question. In that, please listen. In that view of the matter, he is permitted to harvest the crop and to maintain the account of the quantum of the crop harvested. So as on 2012, this court has recognized the fact that he is in possession. This court has directed him to deposit the value of the crop. And this order has attained finality. As much as, therefore, I will only simply continue this order.
And requesting that we will keep the revenue away. The lordships are not agreeing to that. I just keep it there for now. And the lordships are going next step, saying that let him go to the personal property.
No. I'm not going to the step that this court has recognized. I'm only following it.
Depends on which one the lordship will have to go to the application. The lordship will have to download the application and the contents were. Plus, this order was fine. If the learner wants to dispute it, yes, there are records. But he was a receiver between 1986 to 1999. Subsequent to which one the receivership could not continue. Subsequent thereof, this tenancy application from the year 2002 proceedings with ensued subsequent to 1999. His tenancy rights were not recognized. They were dismissed. But what we saw before this court was, he says that he was a receiver between 1989, 1986 to 1990. He is a receiver. He he is an official administrator who was appointed by the court and he was to be answerable to the court. Hence, for those years, whatever he did so as a cultivation or as a measure of cultivation, he is bound to deposit the crop revenue for those years. And once we had evaluated, I had evaluated as around rupees 1,20,000 for those 13 years. My learned friend first filed a counter saying that no, there were expenses involved, and within those times the crop share was that much, and he said not should be deposit 30,000. For which not, he said that's all right, 30,000 should do the job. First, because the accounts from 1986 to 1999 had not been deposited. That was what not led to the application, and that is the premise on which the order stands. That is why we are not saying that if your lordships are saying appointment of receiver or giving handing over the position, not virtually allowing the position, and not putting that before the horse, and not I don't think we have to take minute before the life, they say that no, the board has granted in position. That would criticize the matter. That is why not I'm requesting the court. The lordships have reminded the matter. All right, we will go before the land court. The lordships have said there are certain revenue activities, follow the order. Because I don't think I can legally object. I requested that it may be kept as a suspended animation. But the lordship says, no, when it comes to handing over of position or taking over of position, since there is a dispute which is pending, the lordship can give us a time, 1 month, 2, we finish it. Then there will be an order which will again, which will be challenged by either of us before the court. The lordship meets. There is the only lacuna in this matter is the Mahajar which is at election is not being considered. And must, why that is also being done. I would also request this one. Let the documentary as well as the oral evidence, which stands from 1977 to 1992, also be considered in Parliament. Why? When that is being done, because there are huge volumes of oral as well as documentary evidence, which must belie each other's case. The only admission not what my learned friend would rely upon is not an admission which is of the year 1992, where not after 4 rounds of remand not for the first time the landowner who is his cousin as well as not who is his relative, that is not both the wife of the petitioner and the wife of the landowner were sisters. Not for the first time in 1994 not she gives a stray admission on the basis of which they claim not there is an admission by the others. Otherwise, there is 6 volumes of evidence not where I don't think in any previous past proceedings a case was made up. Which means so that I would request this court that let there be let this let direction be effect that it's a request and not it's a request. Let there be a direction that the evidence from 74 to 92, like the lordship has said. My lordship will say that prior to 92 consider magistrate.
Prior to 2002. Prior to 2002 as ordered earlier.
92 evidence.
Last time ordering both of you have accepted.
That's a
Division bench has said evidence only as on 3rd of October 2002 will have to be considered. No further evidence. All they have said is I have repeated that. Single bench order, they have referred to the order of the division bench, which says 3rd of October 2000.
The order of 1990. The division bench said in 1992 made evidence to other. That's all. Because the word 2002 it has some implication because both of us knowingly or unknowingly related evidence between 92 and 2000. So that was what was actually referred to.
Whatever is the order of division bench, that stands. I will not. That's all.
So the evidence prior to 1992, that is between 77 to 99, that we considered along with this court margin and not written from the country. The lordships could also do this exercise and just ask. Lordships could also do this exercise. Because this is an option.
I offered you to decide the dispute here. You did not want that.
Deciding the dispute first, I think we have to go to 6 volumes of evidence.
I was ready, you were not ready. On 27th of June 2012, this court has the following order. Thereafter, by an order dated 3/1/2014. This court directed the petitioner to deposit a sum of rupees 62,400 as proceeds of the sale of the crop. Subsequently, on 4/2/2014, the order dated 3/1/2014 directing deposit of rupees 62,400 was modified, and the petitioner was permitted to deduct the amount mentioned in Annexure A and to deposit the balance amount, and was directed to furnish the accounts in the property in question from 86 within a period of 4 weeks. These orders indicate that the petitioner has been in possession of the property since 1986, and this has been recognized by this court. In that view of the matter, there shall be an injunction in favor of the petitioner pending reconsideration of the land tribunal. The amount in deposit before this court shall stand transferred to the land tribunal, and the land tribunal shall pass appropriate orders on the amount and deposit after final orders, while passing final orders on the application. Shri Sunil Rao.
This last part, whatever you I would request, they help the state for limitation. Because I'm just taking this.
Shri Sunil Rao, however, strongly objects for the grant of an interim order pending reconsideration of the land tribunal. In my view, since the petitioner has had the benefit of an order since 2012, and it is recognized by this court that he has been in possession since 1986, the objections of Shri Sunil Rao cannot be sustained, more so when no challenge has been made to the above mentioned orders passed by this court.
I pray for the of this question.
The prayer made by Shri Sunil Rao for stay of the order of injunction is refused.
Number 1,
use the records now.
95 matter.
Routine years, they filed an application for restoration of the reputation, saying that the order of the court was against dead person. Then the matter was restored.
Why do you want the records of the land tribunal?
Farm number 7 was with respect to different survey. There was absolutely no claim with respect to the property belongs to the Temple Ward in respect to survey number 151. What my learned friend says that during the course of
Oh, the identity trust law. Did you produce anything to show that you had a right to challenge this? ತರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲ ಅದು ಫಾರ್ಮ್ ನಂಬರ್ 7 ಗೆ, ಬಟ್ ಯುವರ್ ಎಂಟೈಟಲ್ಮೆಂಟ್ ಟು ಚಾಲೆಂಜ್ ಅವ್ರು ನಿಮ್ಮ ಮೇಲೆ ಆಗ್ತಾ ಇದ್ದಾರೆ. Next Wednesday final. If it does not come, I'll decide it on merits. ರಘುಪತಿ ಅವರೇ, ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ, ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಇವ್ರಿಗೆ 2 ಸಲ ಹೇಳಿದೆ, ನನ್ನ ಹತ್ರ ಮಾತಾಡ್ಸೇ ಇಲ್ಲ ಅವರು. ರಾಜಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರಲ್ಲ ನಂಗೆ.
agreeable to share the property. Based on the.
Yeah, what is the point in talking to me? You should talk to Mr. Raghupati and then say yes or no.
ಮಾತ್ರ ಹೇಳೇ ಇಲ್ಲ ಅವರು ಯಾವ್ದು ಹೇಳಿಲ್ಲ.
To keep a senior counsel waiting and if you don't inform him. Will you call him today and finalize? ಇವತ್ತು ಸಾಯಂಕಾಲ ಫೋನ್ ಮಾಡ್ತಾರೆ ಅಂತ ರಘುಪತಿ ಅವರು ನಿಮ್ಗೆ.
ಆಯ್ತು, ಅವರು ಬೈಕ್ ಹತ್ರನೂ ಮಾತಾಡ್ತಾ ಇಲ್ಲ, ನಂಗೆ ಕೇಳಿಸ್ತಾನೂ ಇಲ್ಲ ಅವ್ರಿಗೆ.
Next Wednesday.
For the respondents, respondents 4 to 6 and 8 to 9 minutes.
Next year, Jane. What is the matter about first?
Grant of land to the government first petition of which is subsequently after lapse of 15 years disputed by some of the villagers, and their representation is considered with the Tahsildar and the reference to the Assistant Commissioner for holding that as if my grant is illegal and not for granted.
When was the land granted to you?
The land was granted in 1972.
Date?
Grant certificate was issued in 1972.
Date?
But the order was passed on 8/9/1970. It's an EM, I think. Grant certificate, page 17. Grant certificate.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಕೊಟ್ಟು?
Grant survey number 67 of Y Hunssenhandi.
ಖಾಲಿ ಇದೆ ಇಲ್ಲಿ, ಖಾಲಿ ಇದೆ ಇಲ್ಲಿ ಅಂತ ಬರ್ದಿಲ್ಲ. ನಿಮ್ದು ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸರ್ವೆ ನಂಬರ್?
Survey number 67.
Measuring?
Measuring 1 acre.
In favor of?
In favor of 1/3. Narasimhappa son of Dev.
It is your husband and father.
Yes, sir. Right, purposes of this order, my lord. Therefore, mutation is affected in the name of Narasimhappa.
When?
That is through MR number 12 of 95/96. But after demise of this Narasimhappa, the revenue records transferred in the name of the petitioner number 2 with consent of his mother and sister through MR number 10 of 2006-2007.
Pillar of Narasimha.
In favor of petitioner number 2. In fact,
This
they
number?
have offered this land as security to PLD Bank. They have raised loan also. But in fact, this original, according to them, they furnished for the bank. They could not be able to take it back.
Then what happened?
But then subsequently, my lord's please, some representation was seems to be given by the villagers, alleging that Narasimhappa illegally got the revenue records in his favor.
When was that given? When was that given?
That was in the year 2006. But thereafter, this proceedings before the Assistant Commissioner were commenced. Annexed next page 70.
No, this was a challenge to MR 12/95/96.
So that by challenging that
That is in favor of Narasimha.
yes, after entering our name in 2006-2007, thereafter they want to the extent of alleging that Narasimhappa has illegally got in the records. Whereas the Assistant Commissioner made a reference to that, page 74.
He says there was no grant in your favor in favor of Narasimha. He finds there is no order of grant.
What is the allegation on the basis of a recommended letter by the Tahsildar? Yadu paper sigta illa, grant agilla, anumana barta ide, what he has referred to. They are not verified. In fact, Now today we have some certified copies issued by the authority. Second file is also prepared by the authority. Survey is conducted by the authority. Boundaries are fixed. All the proceedings are held by them. Let them verify their records proper. One officer ಇದ್ರೆ ನಾವು ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಕೊಡಲ್ಲ, ಇನ್ನೊಬ್ರು ಇದ್ರೆ ಕೊಡ್ತಾರೆ. ಮತ್ತೆ ಇದರಲ್ಲಿರೋ ಫೈಲ್ ಅಲ್ಲಿರೋ ಮತ್ತೆ ಸಿಗೋದಿಲ್ಲ.
No, the finding appears to be that ತಹಸೀಲ್ದಾರ್ ಶಿಡ್ಲಘಟ್ಟ ತಾಲೂಕು ಇವರು ಆರಕ್ಷಕ ಉಪನಿರೀಕ್ಷಕರು ಶಿಡ್ಲಘಟ್ಟ ಗ್ರಾಮಾಂತರ ಉಪನಿರೀಕ್ಷಕರು ಠಾಣೆಯವರವರಿಗೆ ಬರೆದಿರುವ ಪತ್ರದಲ್ಲಿ 1ನೇ ಪ್ರತಿವಾದಿಯು ತನಗೆ ಮಂಜೂರಾಗಿದೆ ಎಂದು ಪಡೆದಿರುವ ಸಾಗುವಳಿ ಚೀಟಿಯು ಫೋರ್ಜರಿ ಸಾಗುವಳಿ ಚೀಟಿ ಆಗಿರುತ್ತದೆ ಎಂಬ ಅಭಿಪ್ರಾಯ ಒಂದು ಮೇಲ್ಮನವಿ ಎಂದಿದೆ.
In this regard, a complaint was lodged against my father to the police. Finally, on inquiry, they submitted a B report. I have like B report. Recently, I got those documents. Let them verify the records. If I am permitted, 2 sets of tickets, sir. Yes.
ನೋಡಿದ್ದೀರಾ? If the allegation that it is a forgery is disproved, and if the order of grant is not, where is the finding that the order of grant was not reflected in your revenue records? If I send it back, they will do the same thing again.
Report referred in page 80 megas. 38/7/1998 complaint of Tasildar is considered.
Read the order of the Assistant Commissioner at page number 73.
73.
Last but 2 paragraphs. Last but 2. ಶಿಡ್ಲಘಟ್ಟ ತಾಲೂಕು.
ಶಿಡ್ಲಘಟ್ಟ ತಾಲೂಕು ಅಶ್ವಬ್ಲಿ ವೈ ಹುಸೇನಹಳ್ಳಿ ಗ್ರಾಮ ಸರಳದ 67 ಎಕರೆ ಜಮೀನು ಸರ್ಕಾರಿ ಬಹುಮಾನದ ಜಮೀನಾಗಿರುವುದು ಇರುತ್ತೆ. ವಾದಕರು ಅವರ ಮೇಲ್ಮನೆಯಲ್ಲಿ ವೈ ಹುಸೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರಳದ 67 ಎಕರೆ ಇದ್ದು ಸದರಿ ಜಮೀನು ಸರ್ಕಾರಿ ಬಹುಮಾನ ಈ ಪೈಕಿ ಎಚ್.ಡಿ. ಮಾರಪ್ಪ ಬೈರೇಗೌಡ ಹಾಗೂ ಎಂ.ಪಿ. ಆಂಜನಪ್ಪ ಅವರು ಸರಳದ 67 ಎಕರೆ ಹಾಗೂ 54 ಜಮೀನನ್ನು ಗ್ರಾಮದಲ್ಲಿ ಆಸ್ಪತ್ರೆಗೆ ದಾನ ಮಾಡಿರುವುದನ್ನು 1ನೇ ಪ್ರತಿವಾದಿಯು ಸರಳದ 67 ಎಕರೆ ಜಮೀನು ದಾಖಲಾತಿಗಳನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ಪ್ರಸ್ತುತ ಇನ್ವಿಟೇಷನ್ ಪಡೆದುಕೊಂಡು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆ ಮಂಜೂರಾಗಿರುವ ಜಮೀನನ್ನು ಒತ್ತುವರಿ ಮಾಡಿದ್ದಾರೆ. ಲಗತ್ತಿಸಿರುವ ಸಾಗುವಳಿ ಚೀಟಿಯ ಛಾಯಾಪ್ರತಿಯಂತೆ ಕ್ರಮಾಂಕ LND CH-24-72-72-73 ದಿನಾಂಕ 8/9/1972 ಆಯೋಗ ಮಂಜೂರಿಯಂತೆ ದಿನಾಂಕ 9/2/1977 ನೀಡಿರುವ ಸಾಗುವಳಿ ಚೀಟಿಯಲ್ಲಿ ವೈ ಹುಸೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರಳಗಳ 67ರಲ್ಲಿ 1 ಎಕರೆ ನರಸಿಂಹಪ್ಪ ಬಿ ನೀರಪ್ಪನವರ ಮಂಜೂರಾಗಿರುವುದು ವ್ಯಕ್ತಪಟ್ಟಿರುತ್ತದೆ. ವಿವಾದಿತ ಜಮೀನಿನ ಬಗ್ಗೆ ತಾಲೂಕು ಕಚೇರಿ ಕ್ರಮಾಂಕ RRT 800-15/99 ಪ್ರಕರಣ ನಡೆದ ಕ್ರಮಾಂಕ LND CH-184-72-73 ಪ್ರಕಾಶ್ ನರಸಿಂಹಪ್ಪ ಬಿ ನೀರಪ್ಪನವರ MR ನಂಬರ್ 15-95-96 ಖಾತೆ ಬದಲಾವಣೆಯಾಗಿರುವುದು ವ್ಯಕ್ತಪಡಿಸಿದರು. ಆದರೆ ದಿನಾಂಕ 2/2/1993 ಅಕ್ರಮ ಸಾಗುವಳಿ ಸರ್ಟಿಫಿಕೇಟ್ ಸಮಿತಿಯು ಅಧ್ಯಕ್ಷರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ಸಭಾ ನಡವಳಿಕೆಯಂತೆ 1ನೇ ಪ್ರತಿವಾದಿ ನರಸಿಂಹಪ್ಪ ಬಿ ನೀರಪ್ಪನವರನ್ನು ಸೇರಿಸಿಕೊಂಡು ಇತರೆ 10 ಅರ್ಜಿದಾರರ ಭೂ ಮಂಜೂರಾತಿ ಅರ್ಜಿಗಳನ್ನು ಬೆಲೆ ಇಟ್ಟಿರುವುದು ಸಮಿತಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದೆ. ನನ್ನ ಅರ್ಜಿನೇ ಇಲ್ಲ.
If you say
ಅರ್ಜಿ ಇಲ್ಲ, ನನ್ನ ಆಯ್ಕೆ ಇಲ್ಲ. For that also I will take endorsement from the office itself.
wait for ಪೂರ್ತಿ ಓದ್ಬಿಡಿ.
I'll show you that endorsement also.
1ನೇ ಪ್ರತಿವಾದಿ
that land now again, that original also.
Read the entire order first. ಪೂರ್ತಿ ಓದಿ ಮುಗಿಸ್ಬಿಡಿ ಅದು.
ಮುಂದಿನ ಪ್ರಕಾರವಾಗಿ ನರಸಿಂಹಪ್ಪ ವೀರಪ್ಪನವರನ್ನು ಸೇರಿಸಿಕೊಂಡು ಇತರೆ 10 ಅರ್ಜಿದಾರರ ಭೂ ಮಂಜೂರಾತಿ ಅರ್ಜಿಗಳನ್ನು ವಿಲೇಖಿಸಿದರೂ ಸಹ ಸದರಿ ನರಸಿಂಹಪ್ಪ ವೀರಪ್ಪ ಅವರ ದಿನಾಂಕ 15/2/1977 ಕ್ರಮಾಂಕ ಪೈಕಿ 1 ಎಕರೆ ಜಮೀನಿನ ಬಗ್ಗೆ ಸಾಗುವಳಿ ಪಡೆದುಕೊಂಡು ಅದರಂತೆ MR ನಂಬರ್ 15/95/96 ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಿಸಿಕೊಂಡಿದ್ದು ಇದು ಅನುಮಾನಕ್ಕೀಡು ಮಾಡಿ ದಿನಾಂಕ 30/7/1998 ಕ್ರಮಾಂಕ LNDCR 30/98/99 ಶಿಡ್ಲಘಟ್ಟ ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಆರಕ್ಷಕ ಉಪನಿರೀಕ್ಷಕರು ಶಿಡ್ಲಘಟ್ಟ ಗ್ರಾಮಾಂತರ ಠಾಣೆ ಶಿಡ್ಲಘಟ್ಟ ಅವರಿಗೆ ಬರೆದಿರುವ ಪತ್ರದಲ್ಲಿ ತಿಳಿದುಬರುವಂತೆ ಚನ್ನಹಳ್ಳಿ ಗ್ರಾಮದ ವಾಸಿ ಶ್ರೀ ನರಸಿಂಹಪ್ಪ ವೀರಪ್ಪ ರವರು ಶಿಡ್ಲಘಟ್ಟ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಹುಸೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 67 1 ಎಕರೆ ದರಖಾಸ್ತು ಮೂಲಕ ಮಂಜೂರಾಗಿರುತ್ತದೆ ಎಂದು ಸುಳ್ಳು ದಾಖಲೆಯನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ತಾಲೂಕು ಕಚೇರಿಗೆ ತಿಳಿಸಿ ಖಾತೆ ಮತ್ತು ಪಹಣಿಯನ್ನು ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ ಅಂತ ಅವರಿಗೆ ತಾಲೂಕು ಕಚೇರಿಯಿಂದ ಸಾಗುವಳಿ ಚೀಟಿಯಲ್ಲಿ ಇಂದಿನ ತಹಸೀಲ್ದಾರ್ ಶ್ರೀ ಉಮಾಪತಿ ಅವರ ಸಹಿಯನ್ನು ನರಸಿಂಹಪ್ಪ ವೀರಪ್ಪ ಅವರು ಫೋರ್ಜರಿ ಮಾಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಈ ಬಗ್ಗೆ ಖಾತೆಯಾಗಿರುವುದನ್ನು ಕರೆಯಲಾಗಿದೆ. ಆದ್ದರಿಂದ ನರಸಿಂಹಪ್ಪ ವೀರಪ್ಪ ಚನ್ನಹಳ್ಳಿರವರ ವಿರುದ್ಧ ಮೊಕದ್ದಮೆ ಹೂಡಲ್ಪಟ್ಟಿದೆ ಎಂದು ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಬೇಕು. 1ನೇ ಪ್ರಕರಣವಾಗಿ ವಿವಾದಿತ ಜಮೀನಿನ ಪಡೆದಿರುವ ಸಾಗುವಳಿ ಚೀಟಿಯು ಫೋರ್ಜರಿಯಾಗಿರುವುದಾಗಿರುವುದೆಂಬುದರ ಬಗ್ಗೆ ಅನುಮಾನವೇ ಇಲ್ಲವೆಂಬ ಅಭಿಪ್ರಾಯಕ್ಕೆ ಬಂದಿರುತ್ತದೆ. 1ನೇ ಪ್ರಕರಣವಾಗಿ ನರಸಿಂಹಪ್ಪ ವೀರಪ್ಪ ಅವರ ದಿನಾಂಕ 21/9/2006 ಪೂರ್ತಿಯಾಗಿತ್ತು. ಅವರ ವಾರಸುದಾರರಾದ 1ನೇ ಮುನಿಯಮ್ಮ ನರಸಿಂಹಪ್ಪ, 2ನೇ CM ಮುನಿಯಪ್ಪ ನರಸಿಂಹಪ್ಪ, 3ನೇ ಪ್ರಕಾಶ್ ನರಸಿಂಹಪ್ಪ ಅವರ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರತಿವಾದಿಗಳನ್ನಾಗಿ ಸೇರ್ಪಡೆ ಮಾಡಿರುತ್ತೆ. ಲೇಟ್ ನರಸಿಂಹಪ್ಪ ವೀರಪ್ಪ ಅವರು ಸಿವಿಲ್ ಜಡ್ಜಿ ಕಿರಿಯ ವಿಭಾಗ ಶಿಡ್ಲಘಟ್ಟ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪೊಲೀಸ್ ನಂಬರ್ 20/2009 ವಿವಾದಿತ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸ್ವಾಧೀನ ಅನುಭವದಂತೆ HM ಕ್ಯಾತಪ್ಪ ರಾಯಪ್ಪ, HB ಮಾರಪ್ಪ ಬೈರೇಗೌಡ ಅವರು ವಿರುದ್ಧ ದಾವೆ ಸಲ್ಲಿಸಿದ ಮೇರೆಗೆ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯವು ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿನ ವಾದಿ ಸಲ್ಲಿಸಿರುವ IA ನಂಬರ್ 1ರ ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರತಿವಾದಿಗಳು ವಾದಿಗಳ ಸ್ವಾಧೀನದಲ್ಲಿರುವ ಸ್ವತ್ತಿನ ಬಗ್ಗೆ ಪ್ರವೇಶಿಸದಿರಲು ನಿರ್ಬಂಧಿಸಿರುವ
This grant order of the year 72 it was subject to payment of upset price. You have any document to show that you paid that money? Because from 72 to 85/86.
No, I agree.
Then
and may not can see in invitation also there is a reference for obtaining loan from the bank.
No, loan you may obtain on the basis of the forged document also. If you don't have anything to show that you paid the premium or the upset price from 72 to
normally I agree with my lord of payment of the premium and also then the grant certificate will be used. I'll verify that.
If that is not there, then
I'll verify that. Madam, if payment of amount is paid, there will be definitely reference in the grant proceedings also regarding receipt of the amount in the treasury.
Learned AG is directed to secure the grant register in respect of Yavalida, and more particularly relating to survey number 67. Wheel is on next witness. Registrants are check mark because there is no finding record by the deputy commissioner that in the grant register no grant is made in the register number 67. No, the assistant commissioner and the DC appear to think that because a complaint is given to the police regarding the alleged forgery. No, that is saying no such application was made at all. No, I also want to see the grant register. Suppose in the grant register there is an entry of the grant, then how can you say that there is no grant? The second question, our application argument over. Let us find out whether there is a grant at all made in this particular village in that particular year. If that is silent, then obviously the grant will be bad.
Definitely, I am not interested. So those documents, once they issue certificate,
Everybody copy.
Let us see.
Again, it will be in this place.
ನೋಡೋಣ ಏನ್ ಮಾಡ್ತೀವಿ. Next Wednesday. Who are you? In what way are you interested? Allow the implementing application.
If it is dependency, I think what we have something.
Let him come
It
on.
doesn't matter, Lord, so long as Lord is slightly close, Lord, whatever, Lord.
The application filed for implementing is allowed since it is contended that the applicants therein are the purchasers of the property from the contesting respondent number 3, na? No, in 50309 from contesting respondent number 3 in WB number 50309/13 and fourth respondent in WP 4662/2010 was said to be amended.
Lord, around 58 acres of the land were acquired, Lord, for the benefit of the petition. In addition to that, Lord, about 5 acres of land were all granted, Lord, to the government belonging to it. Lord, there is now a dispute, Lord, between the petitioner, Lord, and the third respondent in respect of, Lord, respective grants, Lord, concerned, Lord, in respect of certain property. As far as, Lord, the challenge by the respondent, Lord, with regard to the grant of the land, Lord, to the petitioner is concerned, Lord, it has ended, Lord, and there is no dispute with regard to, Lord, a grant of land, Lord.
How much was granted to you? How much was granted to you?
5 acres.
Survey number?
Survey number 23. In survey number 22, Lord, 35 guntas. In survey number 23, Lord, 4 acres, 5 guntas. In all 5 acres.
Sir, come again. In 22, how much?
22, Lord, 35 guntas.
And in 23?
23, Lord, 4 acres, 5 guntas. Whereas, Lord, the respondent is claiming, Lord, that he has been granted, Lord, 3 acres.
When is your grant?
Survey number 23.
When is your grant?
Lord, my grant is, Lord, 93, Lord.
And in favor of the third respondent?
That is, Lord, he claims, Lord, it is on 21/5/1965. May I just request,
Same
Lord,
survey number.
Lord, grant certificate that is produced.
But
Lord, that
he claims 22 and 23 or just 23?
Only 23. Only 23.
What is the extent that is?
3 acres.
What is the extent that he claims to have been granted?
3 acres.
This is Nagaraju.
Yes.
And what about the other fourth respondent in the other matter? No, in the connected matter. That is.
Same matter. It is the offshoot of the first matter.
Which should I take up first? The
No,
fourth.
it doesn't make any difference, Lord. In pursuance of the first order, Lord, the second order is passed by the Tahsildar, Lord, for Durasti. So it will go along with the first matter. May I request you, Lord, to kindly see, Lord, annexure C, Lord, R2, Lord,
In which case?
in Lord, the first matter. In 4662 of 2000.
The second matter.
2000.
Objections of?
Lord, respondent. Respondent number 4, Lord.
Yes.
That is not.
Annexure?
Annexure R2. He will rest his claim, Lord, on the basis of this grant.
ಪೈಕಿ 3 ಎಕರೆ ರೆವೆನ್ಯೂ ಸ್ಕೆಚ್ ಅಂತೆ ರೆವೆನ್ಯೂ ಸ್ಕೆಚ್ ಮೇರೆಗೆ
Kindly see, Lord, the second page.
Yes.
Though, my Lord, grant is said to have been made in 1965. Backward sheet is said to be not issued on 65. This certified copy is not said to have been issued not somewhere in 1985. This is a certified copy. If they produce the original ballot, that will change it. Our specific case is ballot, no grant is made. We have produced the register of grants. Nowhere this number ballot is reflected. It is a force.
Srinivas.
Kindly see ballot at the bottom of the cell.
Question by client does not arise. That is because, as secretary by the relevant question, as soon as 23 and 25 together by a person land, that land is intact. And he takes the contention before the commission, that is thereby connected A. There is a overlap. Therefore, the commission, all right, let us have a separate. That's how the assuming that you are not, if there is no overlap, my grant is concerned, how can you question it? What is the lowest grant? It is only the government that best can sustain it. He has no lowest grant. As far as we are concerned, he is earmarked for
No, suppose he is able to establish that there is no grant at all. Where is the question of durasti then?
Appreciate. As far as 5 acres is concerned, there is no dispute. They are not dispute. Therefore, your worship is 5 acres is there. The rest of the land in survey number 23, whether it is granted in favor, it is not granted, or the government has found by Delta side, that will not affect him. Therefore, he can't question my grant.
If there is a grant.
If I am assuming there is no grant, any question my grant.
If there is no grant,
Yes,
as per the records, if it indicates that there is a grant in his favor.
Accordingly, we are saying that 5 acres is there. Apart from that, there is a land in the survey number 23. There is very 3 acres.
Let me first satisfy myself whether 5 acres is granted to you.
3 acres.
Let 3 acres. Let the government say, because they refer to a revenue sketch. They refer to a revenue sketch in your grant certificate.
Government is not issuing my grant. In the second situation, petitioner, unless his 5 acres is encouraged by anything.
When you admit ಮಾಡ್ಕೊಳ್ತೀರಿ, admit the grant in favor of the Nagushan's client. Print target 79 ಅಂತ. Make your stand clear. That is probably because the certificate copy was issued in 81. Therefore, they have used that particular form of their 79.
But here we thought about to produce the original copy. He is holding the production of the original.
Let them produce a register itself.
But I have the copy of original or produced not before all the other. And even in the suit also. But there is
ಇಲ್ಲ
no
original ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? Original ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? Because where is the order of grant? There is a reference in annexure R2 at the beginning. Allah, there is an order which is referred to in annexure R2, which is not legible at the top portion. La, ಆಮೇಲೆ first grant certificate. In what way does it improve your case? Is there a grant or not is what we have to see. If you have the certificate, if you have the original of this grant certificate, please produce. Or else I'll record a statement that it is not available with you. Now that I will secure. Then at counsel for the extra respondent, both respondent submits that he will also make an attempt to secure and produce the original order of grant said to have been made in favor of his client. Release next Wednesday.
I will produce the copy of
First let them commit themselves.
I will give the copy and file it in the office. I obtained the certified copy from them. There is no reference to this order.
Affidavit ಹಾಕಕ್ಕೆ ಹೇಳ್ತೀನಿ. Be careful. ಯಾರು? ಏನ್ ಮಾಡಿದ್ರು ಸುರಣ್ಣ ಅವರ? ಅಪೀಲ್ ಇಲ್ವಾ ಇದ್ರ ಮೇಲೆ? ಅಪೀಲ್ ಇಲ್ವಾ? ನೆಕ್ಸ್ಟ್ ಹೆಚ್ ಮೇಲೆ ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ ಮೇಲೆ
kindly say what has happened. 4 acres 32 guntahs of land was acquired with permit.
Take steps against him first. Take steps against him because if he is affected by this order.
More reputation. Filed by him that was disposed of his property. In that petition, I have filed an application for restoration that will also be filed.
Yeah, subject
19,598
subject
of 2013.
classification.
Application is filed on.
Classification. It is stated that
On 4th July 2017, I filed the application.
Stated that in a connected petition, that is WP number
19,598 of 2013.
when
ಮುಂದೆ ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ಟಿದೆ ಅದನ್ನ ರೀಕಾಲ್ ಮಾಡಿ ತಿರ್ಗಾ ಕೊಡ್ತಾ ಇತ್ತು. There is an order on this court to club both them. A club order post out this court.
it is stated that there is a connected petition in WP 1958 or 2013 by Sri P.D. Suran.
I filed the application on 5th
The
July.
office is directed to post the above stated petition along with the said petition.
Along with the IA filed by me on 4th July.
It is also stated by learned counsel by Shri Bhargav that the fourth respondent is no more. Steps, if any, be taken by next week. Next week, on next Wednesday. Let us see.
There is a fact. First, ಎಲ್ಲ
This matter.
Next week ಬರಲಿ 2013 ಮಾಡಿ ಕೊಡ್ತಾರೆ. ನೀವೇ ಅಪ್ಲಿಕೇಶನ್ why do you want to file an application and come on record? Why do you want to file?
That will be more easy for us.
Yes, serial number 6.
That I beg to appear for respondents 5C and D.
Yes. 5A and 5B in place of G.A. Vishwanath Reddy. ಹಾಕಿದಾರ ವಕಾಲತ್ತು? Shri so and so states that he has received no objection to enter appearance on behalf of R5A to D, na? R5A and B. You have the NOC? The same is taken on record. Office to print his name in the cause list. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕಿರೋದು. Next witness. What's the proposal? What is the next rich? Page number in the next rich.
Proposal made by the National Elections Commission. Then we have opposed
Has there been a order passed with the Deputy Commissioner? There's only a communication between the AC and the DC. No, this is only a proposal. The Deputy Commissioner may or may not accept it. What has happened? In what way are you interested in this land? The reservation is in accordance with the rules. Again, what is wrong? Let them make a proper, let them first reserve it, then challenge it. Why do you want to preempt them right now? Therefore, Deputy Commissioner may reject this proposal. He may reject the proposal. The order impugned to the reputation is a communication from the Tahsildar to the Assistant Commissioner proposing reservation of land bearing cell number 36, measuring 63 acres. In my view, since the order at Annexure H is only a proposal, proposing reservation of the lands, the petition is premature. The petition is dismissed, reserving liberty to the petitioner to challenge the reservation, if any, finally made and approved by the authorities. ಯಾಕೆ ಬೇಡ ಸುಮ್ಮನೆ ಆಮೇಲೆ ಅಗೇನ್ಸ್ಟ್ ಮಾಡ್ತಾರೋ ಸುಮ್ಮನೆ ಇದ್ಬಿಡಿ ಮಾಡಲಿ ನಿಧಾನಕ್ಕೆ ಮಾಡ್ಕೊಳ್ಳಿ ಇದಕ್ಕೆ ಬಿಟ್ಬಿಡಿ ಸುಮ್ಮನೆ
Petition is a great thing on number 4. I am taking this step. I have the affidavit for filing necessary application for bringing the last petition to number 4. Private respondent. My application is rejected.
Next Wednesday. Next Wednesday. Repeat my name. Other matters will be repeated next Wednesday. Learned Counsel submits that the first petitioner is no more and the other petitioners are the LRs of the deceased first petitioner. Memo is accepted. The other petitioners are treated as the LRs of the first petitioner. Necessary note be made in the cost rate. Okay. Next Wednesday.
No, I would agree with that.